We'll come to order, and we're doing the pursuant to the order reference of Tuesday, November 6, 2018, Bill C-86, a second act to implement certain provisions of the budget tabled in Parliament on February 27, 2018, and other measures. My apologies for us starting a little late. The Prime Minister and the Leader of the Official Opposition, Leader of the Third Party, are making statements in the House on the Jewish refugees that were prevented from coming into Canada on the boat to St. Louis. And that's why we're short a few members, but we are worried about getting tight on your time too. So with that, we'll start with the Canadian Centre for Policy Alternatives. Catherine Scott, welcome, and thank you all for coming on very short notice. I know that. Go ahead, Catherine.
Thank you, Mr. Chair. And thank you very much for the opportunity to address you today on the Budget Implementation Act. My name is Catherine Scott, and I'm a senior researcher with the Canadian Centre for Policy Alternatives here in Ottawa. Bill C-86 marks an important milestone for Canada with the introduction of Part 1 of Canada's first Poverty Reduction Act, followed quickly this week with Bill C-87 yesterday, as well as 3 other pieces of legislation enshrining the principle of gender equality and efforts to advance gender equality through policy and program. These bills have been a long time coming. The call for proactive pay equity legislation reaches back decades and has been a recommendation in the CCPA's alternative federal budget for many years. With this bill, federally regulated employers will be required to create proactive pay equity plans that will help to chip away at Canada's stubbornly high gender pay gap and to uphold women's right to equal pay for work of equal value. The Canadian Gender Budgeting Act will require governments of the day to assess and report on the impact of all new budget measures, including proposed revenue generation and program expenditures, using a gender and diversity lens. And the new Department for Women and Gender Equality will ensure that the federal government is actively engaged in supporting women's rights and gender equality through its own policy and research, as well as providing much-needed support to government agencies and civil society organizations working in communities across the country. These are foundational pieces for a more inclusive, a more just, and a more prosperous country. At the same time, at a time when there's a mounting backlash against women's rights, these efforts are significant and important to ensure, as the preamble to proposed legislation for the new department attests, that all have the opportunity, equal with others, to make for themselves lives that they are able and wish to have. The provisions for gender-based budgeting are also essential in modernizing Canada's processes for policy and program development. Around the world, gender budgeting is recognized as key to generating the evidence necessary to inform policy and program that successfully deliver on their stated goals and contribute to broader societal well-being. The new Act provides a vehicle for strengthening accountability and transparency, both key characteristics of effective public policy. It's one thing to know, for example, that a measure like the employee stock option costs Canadians $755 million a year in foregone revenue. It's another thing to know that 77% of those benefits are claimed by men. The partial exclusion of capital gains delivers 75% of its benefits to men at an enormous cost to the government of $6.6 billion. These policies effectively amplify existing gender disparity in the labor market. A gender analysis poses fundamental questions. Are these tax expenditures effective in achieving their stated goals? Are they just? Could Canadian tax dollars be better spent elsewhere? The work of the new department and those charged with carrying out GBA Plus analysis will require sufficient resources to ensure the positive impact of this work. This will include mechanisms for meaningful engagement with and support for women's rights and gender equality seeking groups. We have recommended an annual budgetary target of $100 million for the new department in the alternative federal budget. So too does the new Pay Equity Act hinge on the resourcing available for the new Commissioner for Training and Education, Compliance and Enforcement. We fully endorse and support the recommendations of the Pay Equity Coalition with respect to proposed reforms, enshrining existing human rights protections, and the call for a robust mechanism for pay transparency. Without these actions, the proposed pay equity model risks becoming a variant of comply and explain, an approach that's met with precious little success in encouraging gender parity on corporate boards. The issue of resources is also fundamental to the potential success of the new Poverty Reduction Act. The Act outlines specific targets for reducing poverty as measured against an official poverty line and establishes a framework and a process for reporting on progress to both Houses of Parliament. At the same time, the Act does not include any new investment in the programs that are needed to achieve the strategy's goals. Indeed, Canada's new plan is really more of a framework than a strategy to accelerate poverty reduction. Strategy implies we have a plan to get from where we are to where we want to go, and crucially, the resources to back it up. On this score, low-income Canadians are still waiting. With urgent need across Canada, an effective poverty reduction plan requires more ambitious targets and timelines, as well as greater investment in programs such as universal childcare, national pharmacare, training and education for marginalized workers, and the like. And lastly, I would like to commend the government for the amendment to the Income Tax Act, with taking up recommendation 3 of the consultation panel on the political activities of charities. This is a very important amendment, and we hope that the forthcoming guidelines coming through from CRA will uphold the letter and the spirit of the bill's proposed amendments. Thank you again very much for your kind attention.
Thank you very much, Catherine. Then turning to the Canadian Council for International Cooperation, Mr. Riley King, Research and Policy Manager, and Mr. Charles, Policy Officer. And I believe the floor is yours, Mr. Charles. Okay.
Thank you very much. Mr. Chair, members of the committee, thank you for the invitation to appear before the committee. We are pleased to appear on behalf of the Canadian Council for International Cooperation, Canada's national coalition of civil society organizations working to end global poverty and promote social justice and human dignity for all. Our 80-plus members include many of Canada's leading international development and humanitarian assistance organizations, and more broadly, we represent a sector including over 2,000 organizations, which employs 14,000 people and spends over $5 billion each year. The 2018 Budget Implementation Act, number 2, will have important impacts on the work that we and our members do to build a fairer, more sustainable, and safer world. Today, we will focus our remarks on 2 areas. First, changes to the rules governing charitable activities in the Income Tax Act, and second, changes to how Canada delivers and tracks its international assistance. CCIC wholeheartedly welcomes the amendment of Section 149(1) of the Income Tax Act to accept and acknowledge the public policy role of Canadian charities. As we indicated in our submission to the Finance Committee during the 2019 pre-budget consultations, Canada's competitive advantage includes ensuring we have a strong nonprofit sector. A precondition of this is a legislative and policy environment that is fully conducive to civil society organizations realizing their full potential. It is therefore good to see that the substance and language of the amendments in Bill C-86 reflect the recommendations of the Independent Consultation Panel on the Political Activities of Charities. We support the continuation of a prohibition on partisan activity by registered charities. However, existing guidance is vague, and these amendments do not clarify, for instance, what exactly is meant by, quote, public policy dialogue and development, end quote, or, quote, indirect support of or opposition to any political party or candidate, end quote. We recommend that these terms defining partisan activity be clarified to ensure that charities can maximize their contribution to Canada's society and economy. We also recommend that these and any other further improvements to the legislation and regulation governing Canadian charities be developed in dialogue with Canadian charities. In this vein, it is worth noting that the amendments proposed in Bill C-86 result from the very public policy dialogue that the Income Tax Act now limits. CCIC and other civil society organizations are keen to keep working with the government and parliamentarians to develop a modern regulatory and legislative framework for Canada's nonprofit and civil society sector. My colleague Fraser Riley King will now turn to the delivery and accountability of Canada's international assistance.
Thank you also for inviting us to appear. For the past 10 years since June 2008, Canada's Official Development Assistance, or ODA, has been governed by the ODA Accountability Act. This act ensures that Canada's international development and humanitarian assistance focuses on poverty reduction, considers the perspectives of poor people, and upholds human rights, and that it is, perhaps most importantly, accountable to Parliament and the public. As written, Bill C-86 amends the ODA Accountability Act in two problematic ways. First, it repeals the current definition of ODA under the Act. The current definition is largely aligned with that of the Organization for Economic Cooperation and Development, the institution responsible for defining and monitoring ODA globally. The OECD is currently considering potential changes to the global definition of ODA. Until this review is concluded, Canada should not change its domestic definition under the Act. Doing so would prejudge the outcomes of this multilateral review and could put Canada out of line with its global peers. Second, Bill C-86 would delay the release of a report required under the ODA Accountability Act. Currently, the Act report provides preliminary whole-of-government information 6 months after the end of a given fiscal year and 6 months ahead of the final annual statistical report. The report provides access to provisional numbers on Canada's ODA. It's an important and timely report for parliamentarians and the Canadian public. But by delaying the release of this report by a further 6 months, there would be no official data on Canadian ODA until a year after the fact, and timing it with the release of the statistical report would make these numbers redundant. We therefore recommend that the current definition of official development assistance and the current reporting schedule under the ODA Accountability Act be maintained. Bill C-86 also introduces the International Financial Assistance Act, allowing the Minister of Foreign Affairs or International Development to offer sovereign loans. We recommend that Bill C-86 be amended to indicate that only sovereign loans that are concessional with a minimum grant element of 25% and which aim to retrieve additional measures in Bill C-86. We commend the creation of the Department for Women and Gender Equality and the Gender Budgeting Act, which will enhance gender analysis in the policy process. This will ensure that Canada's actions support implementation of Sustainable Development Goal 5 on gender equality, both at home and abroad. Secondly, the Poverty Reduction Act represents another important step towards aligning the global sustainable development agenda with Canada's domestic action. However, here we urge the government to aim higher. Our goal in Canada and overseas should be to eradicate poverty, not merely reduce it. With that, we'll close. Thank you again for your attention. I look forward to any questions.
Thank you both. Canadian Labour Congress President Mr. Houseff and Ms. Smallman, Director, Women's and Human Rights. Welcome to you both.
Thank you, Chair. Committee members, good afternoon. Thank you for the opportunity to appear before you today. And of course, Bill C-86 contains many provisions that are important to working people. I welcome any questions you may have in any aspect of the bill. However, I will confine my opening remarks to pay equity provisions and, of course, the amendments to the Federal Labor Standards, Pay Equity Act. We're glad to see the Federal Pay Equity Act finally being tabled. Working, of course, women have been calling for this legislation for decades. This historic legislation will hold, of course, employers accountable for the proactive identifying and correcting systemic wage discrimination. And it will put, of course, working women in the federal sector on path towards equal pay for work of equal value. We also want to commend the government on repealing the Public Sector Equitable Compensation Act brought forth by the previous government. We're pleased that the bill, of course, provides for pay equity committees about to be developed and review pay equity plans. The bill also established a pay equity commissioner to administer and enforce the bill. We hope, of course, the Commission and their team will have the resources and capacity required to implement the legislation effectively. There are some parts of the bill which we need to change in order to reinforce pay equity as a human right and to ensure the process works to accomplish, of course, the goals of ending systemic wage discrimination. First, the purpose clause must be amended to remove qualifying phase working towards removing the qualifying phase while taking into account the diverse needs of employer. This language in this part of the Act undermines the intent of the Act as well as the human rights of equal pay for work of equal value. Second, the language on voting in pay equity committee states that the decision of the employees group must be unanimous or they will forfeit their right to vote. We suggest that that a majority agreement is sufficient as in the case of the Quebec legislation. Finally, the language on maintenance provides for retroactivity. Where wage gaps have arisen in the interim between posting of the original pay equity plan and the 5-year review. However, it is retroactive to when the revised pay equity plan was posted, not, of course, when the gap first occurred. A similar provision in the Quebec legislation was recently, of course, struck down by the Supreme Court of Canada. The Federal Act, of course, should not replace this unconstitutional language. Federal labor standards. Bill C-86 makes a variety of changes to the federal labor standards. In our opinion, these changes are overdue and are much needed. Since the comprehensive Harters Commission report was published in 2006, the federal labor standards have lagged behind provincial improvements. Many improvements that have failed to keep up with significant changes in work and the world of employment. We're pleased that the victims of family violence will now be entitled to 5 paid days for domestic violence leave. We welcome the prohibition on paid discrimination on the basis of employment status. Equal treatment protection in the code will reinforce the new pay equity legislation. They will benefit low-income workers, women of color, and newcomers to Canada, who are more likely to be employed in part-time, temporary, casual, or seasonal work. Temp agency workers will also be entitled to equal treatment. We also welcome the onus on employers to prove that they are not misqualifying employees as self-employed workers or independent contractors. These changes help bring the federal labor standards, of course, into the 21st century. I do want to say that Canada's unions are not, of course, satisfied with the provision to end, of course, contract flipping at airports and federal workplaces. Bill C-86 provides some protection for non-unionized workers in contract retendering. However, we feel the government missed a chance to stop employers from terminating bargaining rights and cutting the wages and benefits of unionized workers by flipping contract. We urge the government to take steps to ensure that all workers are treated fairly in such a situation. I want to thank, of course, the committee for the opportunity to, of course, to present here today, and we'll take any questions you may have in regard to my presentation.
Thank you very much, Mr. Youssef. Canadian Union of Public Employees, Mr. Desjardins, Executive Assistant, National President's Office. Welcome, Inek.
Bonjour, bonjour, je parle en français. I will speak in French today. I'm pleased to be here this afternoon to speak to you on behalf of the 665,000 members of the Canadian Union of Public Employees, CUPE. Now, CUPE welcomes Canada's long-awaited pay equity legislation, which will have an important impact on over 23,000 of our members who work in federally regulated industries. These members work mainly in the private sector, such as airlines, telecommunications, ground transportation, and ports. We also represent employees at the RRCMP. We have 4 decades of experience with provincial pay equity regulatory regimes. And we believe that the federal government should be setting a high standard for the provinces to emulate. I'd also like to mention that we have successfully challenged the constitutionality of certain provisions on pay equity legislation, specifically in Quebec. I was the lawyer on this file for CUPE in the matter that Mr. Youssef referred to that led to the Supreme Court ruling in May. So if you have any questions about that, I'd be happy to respond. We agree with the CLC's remarks, so That means I will move directly on to the next page of my notes so that you don't have to listen to me repeat anything. Now, a gap that we immediately identified in legislation to ensure that it meets constitutional standards is that there needs to be an overall standard of non-discrimination applied to all of the elements of pay equity plans and their application. It's simply a matter of adding in a section, or adding a few words in section 2 to ensure that the obligation is permanent and to ensure that all aspects of pay equity will be free from gender-based discrimination. And we will even recommend a wording for this. We agree, once again, with the CLC's comments on the functioning of committees and unanimous votes from employees. From experience, we can state that something that can occur is that when there's a requirement for unanimity among employee members, the employer can easily convince a single employee to take a different position or to take the position of the employer, especially if most of the members are male, and that means that the voices of women around the table are being trampled. When there are multiple bargaining agents on a committee, unanimity among the employee representatives will often be difficult or impossible to attain, so we need a majority vote and not unanimity. Now, with regard to the compensation comparison method described in Section 50 of the Act, we can say right away that what is described in Section 50 will likely be inapplicable in most cases. We really don't understand why the Act does not include the comparison method that was recommended in the 2004 final report of the Pay Equity Task Force, usually called the Bilson Report. We will elaborate further on this shortcoming in our written brief, but we want you to be aware immediately that this is an important problem. As the CLC mentioned, with regard to the retroactive pay adjustments, there's nothing clear about that in the legislation, and that may have an effect on the constitutionality of the bill. And so we hope you have noted that. And in conclusion, when it comes to the Pay Equity Act, it gives a significant degree of responsibility to the Pay Equity Commissioner. In order to ensure that the legislation is not a burden to businesses, we need to ensure that there are the appropriate resources to support them. And we need to give the resources necessary to the Commission to also resolve any disputes in a rapid and effective manner. We need them to have all the resources necessary to fulfill the new role. And finally, I would like to say that the dispute settlement mechanisms found in Part 8 should not distinguish between employees and the remedies offered to employees and to bargaining agents. Bargaining agents, unions, for example, should be able to exercise all the rights of their members on their behalf. That's part of the freedom of association, the freedom to be represented by an association, and that needs to be stipulated in the legislation. In fact, there can be reprisals, and this is recognized in legislation. There can be reprisals when someone makes a complaint, but does not protect the union's capacity to act in those cases. So I would like to ask you to note that. And finally, the last remark I want to make today is that the amendment to the Canada Labour Code, which is about pay equity, so I'm talking about 182.1 to 182.4, and this is about equal treatment provisions. Well, I would invite you to read our written brief, which we will table by Friday. We have recommendations on this to include the interpretation, because the interpretation, this will be done by regulation. And so the regulation should ensure that there is no discrimination based on the hiring date. And that's the end of my presentation today. I'm ready to answer your questions.
Thank you very much. Canada Without Poverty, Ms. Farah, Executive Director, and Ms. McLachlan, Deputy Director. Welcome to you both.
Thank you. Good afternoon, and thank you for the opportunity to address this committee. My name is Harriet McLaughlin. I'm Deputy Director of Canada Without Poverty, and I'm joined today by Canada Without Poverty's Executive Director, Leilani Farha, who is also the UN Special Rapporteur on the right to adequate housing. CWP is a nonpartisan, non-for-profit, and charitable organization dedicated to ending poverty in Canada. For nearly 50 years, Canada Without Poverty has been championing the human rights of individuals experiencing poverty, and since our existence, the Board of Directors has been comprised entirely of people with the lived experience of poverty. This committee should know that though I'm an educated professional, I lived for almost 35 years in poverty, 19 years as a single parent. Canada Without Poverty has long called for a national anti-poverty strategy to be secured in legislation. As members of this committee may be aware, United Nations authorities, for example, the UN Committee on Economic, Social and Cultural Rights, have urged Canada to secure its efforts towards the rights to an adequate standard of living, housing and food legislation. We support the entrenchment of the Opportunity for All strategy within Bill C-86 as critical to the fulfillment of Canada's international human rights obligations. While the strategy and legislation reference the Sustainable Development Goals, the target and timeline invoke the minimum threshold of a reduction poverty by 50% by 2030. The reality is that when we only commit to reducing poverty, we create opportunity for some and not opportunity for all, especially those who are the most marginalized. For a country as wealthy as Canada, who should be leading other countries in the implementation of the SDGs, we are disappointed the legislation does not commit to the spirit of the SDG 1, which is to end poverty. I'll pass it over to Leilani.
Thank you, Harriet, and thank you, Chair. Good afternoon. My comments are going to focus on Part 1 of C-86, particularly the provisions related to political activities and purposes of charities at Section 17 of the bill. Let me begin by saying that CWP is pleased to say to the committee that we support the proposed amendments, and we do so for the following 3 reasons. First, and perhaps most obviously, these provisions actually strengthen our democracy. They ensure robust public debate and discussion, and that the voices and lived experiences of persons living in poverty can be heard in the public domain. Second, and as Catherine Scott already said, the amendments support recommendation number 3 of the consultative panel that deliberated on these issues. And I'd add to that the amendments also are consistent with the Ontario Superior Court's ruling in the case that my organization brought on the very issue of restrictions on political activities of charities. For those of you who've read it, you'll know, and for those of you who don't, I'll tell you that Justice Morgan in that case ruled that restrictions on nonpartisan political activities curtail CWP's ability to engage with our members and the public in pursuing our charitable purpose of relieving poverty. And that unlike old models of almshouses and soup kitchens, CWP's work to relieve poverty by sharing ideas, achieving attitudinal changes, and engaging in public policy dialogue to identify the causes of poverty and the necessary changes to laws and policies to relieve poverty are necessary for the achievement of our purpose, which is charitable. He determined, in fact, that Section 149.162 of the Income Tax Act is a violation of Section 2B of the Charter. That's the free expression article in the Charter. And that such a provision was not reasonably justified, and that the provision is of no force and effect, and that henceforth charitable activities must be understood to include non-partisan political activities in furtherance of a charitable purpose. And that's exactly what the proposed act is saying as well and is consistent with. The third reason we support the amendments is because, like Justice Morgan's decision, they do not in any way allow groups that do not have an accepted charitable purpose to claim charitable status for political activities. Rather, the changes simply recognize that freedom of expression and participation in public policy dialogue are critical components of the effective pursuit of accepted charitable purposes, such as the relief of poverty. Before I close, I just want to note something for the committee. The government has not yet indicated an intent to withdraw its appeal in the decision of Canada Without Poverty versus Canada, and has not recognized yet publicly that the sections of the Act are in fact a charter violation. And in fact, the government has chosen to frame the issue as one that's simply a matter of policy. For our sector, it is critical that the sections of the Income Tax Act that are being amended remain recognized as a violation of the Charter. Otherwise, similar measures could be implemented on a political whim by future governments, leaving the sector exactly where it was prior to the suggested amendments in Bill C-86. So we ask, therefore, and in closing, that the government withdraw its appeal in this case. Thank you, and we're happy to take any questions.
Thank you both. Turning then to the YWCA, Ms. Sultana, Policy and Strategic Manager, Policy and Strategic Communications.
Thank you. Thank you. Good afternoon, fellow members of the panel, as well as honorable members of the Standing Committee on Finance. We thank you for the invitation to appear here before you today. Once again, my name is Anjum Sultana, and I am the Manager of Policy and Strategic Communications at the YWCA Canada. We are the nation's oldest and largest women-serving organization, and for nearly 150 years, we have been working with women, girls, and their families at critical turning points in their lives and providing them with the necessary services and resources to thrive and succeed. Last week on November 1st, over 100 members of the YWCA Canada were here on Parliament Hill and met with over 65 members of your fellow parliamentarians, and we advocated for women's economic security. Today, we will comment on the contents of Bill C-86, and we are encouraged by many of the developments that have occurred in this particular bill, because we see that there is an opportunity to advance women's economic security here in the country. And what we also wanted to share was that we currently work in 9 provinces and 2 territories, and we work with over 330,000 women and girls every year. And we're actually anticipating by 2020, our 150-year anniversary, we will be working also in our 10th province, which is Prince Edward Island. So what we want to do today is talk about 3 particular divisions of Part 4 of Bill C-86. In particular, Division 9 of Part 4, pertaining to the Canadian Gender Budgeting Act to promote gender equality and inclusiveness by taking gender and diversity into consideration in the budget process. We would encourage, as others have testified to this committee before, that to follow this landmark legislation, it would be critical to ensure that as future standing committees on finance consider pre-budget consultations, that there be a target of gender parity. And specifically, others have testified before this committee the importance of ensuring that at least 15% of future witnesses to this committee be from feminist and women-serving organizations. The Canadian Gender Budgeting Act marks an important milestone that can be further enhanced by ensuring that at least 15% of the witnesses to this committee come from feminist and women-serving organizations to truly ensure that women's voices are heard in the budget making process as well as future decision-making processes. We're also pleased to see inclusion in this bill of Division 14 of Part 4, which enacts the Pay Equity Act, a call that women-serving organizations have been pushing for many years, including colleagues from the Equal Pay Coalition, Janet Borwo and Faye Faraday, who have appeared before this committee earlier in this committee's consideration of Bill C-86. We fully support their recommendations, and in our future brief to this committee, we will delineate exactly the specific recommendations, but we fully recommend their calls. One that we want to draw your attention to is the specific point around the purpose clause, which is clause 2, which has a current language around ensuring that the diverse needs of employers are kept in mind. We would encourage that this be deleted, because what we have seen is that this undermines women's experiences in the labor workforce, and also undermines the Act's purpose and intent of addressing systemic gender bias and discrimination. We would also recommend that sorry, I will continue on with my comments. We were also pleased to see that in Part 4 of this bill, Division 18 was the piece of legislation to enact the Department for Women and Gender Equality. We were pleased to see that there were many other considerations of diverse social locations and diversities that were embedded in this particular piece of Bill C-86. We would encourage that there be further inclusion of another identity, which is citizenship. We saw that there was indication that there's an understanding that the diverse experiences of women that are complicated by different aspects of social locations, such as age, ethnic origin, and sexual orientation, were considered. We would also encourage that citizenship be another addition to that list. And the reason for this is that this is consistent with other provincial human rights codes, such as Ontario, which includes citizenship. Finally, what we would like to say is that we wholeheartedly agree and support the recommendations of our colleagues at the Canadian Labour Congress with respect to recommendations around leave. We see this in the women we serve every year, over 330,000, many of whom are from working class backgrounds and experience challenges in accessing their entitlements. So we would encourage that the recommendations put forward by the Canadian Labour Congress to this aspect be also considered. Finally, I'd like to thank you again for your attention, and we look forward to any questions that you might have. Thank you.
Thank you very much, Ms. Sultana. We'll go to 5-minute rounds due to time frames. Mr. Fergus.
Merci beaucoup, Monsieur le Président. Puis je vous laisse tout le monde.
Thank you very much, Mr. Chair, and I'd like to give everyone time to put on their headsets. Firstly, Ms. Scott, I'd like to offer our deepest sympathies for the passing of Kate McIntyre at your organization. She appeared before the committee on several occasions and represented your organization very well, as well as the files that she wanted to put forward. It is a huge loss, and on behalf of all of the members of this committee, I would just like to say that we really felt her passing and would like to offer our condolences. Now, I'd just like to ask a little bit about your analysis of the gender equity part of the bill. Could you tell us a little more about your analysis of these provisions? You indicated that it's a good beginning, but that there's more to be done, or that some corrections need to be made. Could you please tell us a little about that?
The gender equity part of which bill? The department or the budgeting provisions?
The budgeting provisions.
The budgeting provisions. The set of budgeting, the gender equality budgeting provisions in the Act are fairly broadly scoped out. We believe that certainly the preamble is expansive, and it directs the Department of Finance as well as other agencies to conduct a gender-based analysis on all measures, on all new budgetary measures, as well as tax expenditures. It's a broad set of directions which will hinge on the level of resourcing that's available, certainly to the Status of Women or New Wage Canada, I guess is the new act, I'm not sure what it's going to be called, Wage Canada, to deliver those resources. We're very, certainly there have been, the department has taken tremendous steps already with investments that this government has made in the Status of Women over the I guess 2 budget cycles. We're encouraged to further invest in the capacity of the Status of Women to achieve those goals and to support other agencies. You know, a lot of this work is very much provide not only assisting with analysis, but investing in the generation of data. Important investments have been made already with Statistics Canada. We need to continue to focus on that, but also to facilitate the meaningful participation of women's rights organizations and those range of groups in the budgeting process. This is really a tremendous opportunity, actually, for the government, as I said, to up its game in policy development, to bring this type of analysis to bear, to really understand the implications and impact of budgetary decisions. And I think it's a tremendous opportunity to also to engage civil society and to increase economic literacy, to generate that kind of engagement, to ensure that we have policies that are effective and deliver the intended impact. We certainly commend the government and are happy and anxious to work to ensure that these provisions achieve their full impact.
Super. Ma deuxième question, c'est pour Madame Desjardins. Madame Desjardins.
Next question is from Ms. Desjardins. Ms. Desjardins, you indicated that your union has been working towards pay equity for a long time. And similarly to what I asked Ms. Scott, you said that this is a step in the right direction, what we started here, but you noted that some of the provisions should be changed. In your opinion, the fact that we included this in the budget, would you say that this is a major step that should be followed and imitated by by the private sector and other sectors of society? Well, we've been waiting for proactive legislation from the federal government for a long time. We have proactive legislation in some provinces that are currently in force and that work relatively well, except for some problems which have brought us before the courts on some occasions. We know that for decades, legal proceedings to try to reach gender equity doesn't work, either for employers or employees. That's why proactive legislation was necessary and long overdue. This legislation overall is a step in the right direction, but there are still gray areas in how the legislation was designed. There are many loopholes for employers, and that will lead us once more to legal proceedings, and that's what we want to avoid: costly litigation, costly for all parties. And with this legislation, that's still a possibility, because not all the loopholes have been closed. It's not a tight piece of legislation. There are too many loopholes, too much discretion for employers. There are also gray areas due to the fact that a lot of elements of it are left up to regulation. If the regulations are well drafted, then it could work, but it's too early to say. We will need a regulatory process that includes various partners. We will need to be consulted, and we will need our point of view as experts, because we are experts in this field.
Mr. Richards, 5 minutes.
Yeah, thanks, Mr. Chair, and I appreciate you all being here today and sharing your perspective. One of the things, I guess, with this legislation that we've heard from, I've certainly heard from a number of organizations and individuals out there, is just looking at the size of this piece of legislation, the omnibus nature of it. There's been many people who've kind of commented on the fact that when you look at the time that was sort of given here for individuals like yourselves, organizations like yourselves, to sort of take a look at this piece of legislation and prepare to comment on it here at a committee, when really there was so little time given, was something that they found really problematic. I wanted to just give all of you an opportunity to comment on your thoughts on that particular aspect of this situation. Although I'd be tempted to play favorites and start with Gavin Charles, who once, I don't know if he's okay with me telling this, but he's not indicating any negative opposition, was once a parliamentary intern in my office, and so I'd be tempted to give him favoritism and let him start there, but I won't do that, and I'll just go from left to right. Anyone who would like to comment, please feel free to do so. I'll just start from left to right. From my left.
First, let me say that there are many provisions in this bill, yes, that have some complexities, and we have examined almost every aspect of it. I think that does not, phase us in the achievement of what the bill is trying to do overall. I think on the pay equity, we've been waiting for decades for a proactive pay equity legislation. We have identified 3 very specific things I think that can be addressed to make this bill even better than what it is currently. Similarly, with the Harry Arter's recommendation finally seeing the light, and the recommendations to improve the Canada Labour Code Part 3, which has not been amended since 1960s. So I think, again, we lay out one area where the government can fix that area, and it's a regulation that would need to be brought forward. But at the end of the day, this is not the first time this House have had to deal with, of course, omnibus legislation. We've been coming here for quite some time, and we're very happy to comment about whatever legislation the government brings forward. We think this legislation will enhance women's gender equality in the federal jurisdiction, but equally so, I think the labour provision will set a new standard for the federal government in trying to get the provinces, of course, to emulate.
Thank you. Is there others who would like to? I saw some heads kind of nodding over here. You probably had comment, I assume. Yeah.
Yes. Yeah. Yes. Well, first of all, I'd say that Canada Without Poverty is really glad that the Income Tax Act amendments made it in. So we're very pleased with that. And in fact, the issues that we cover that are included in the BIA are issues that have received a whole heck of a lot of consultation, actually. So we had plenty of time to engage, and we're happy that many of them have made it in.
Okay. Is there any others that would like to comment in particular on that? And after all that for Gavin, he didn't even comment. Yeah. Anyone else? Okay, no, I talked him into it. Yeah.
Some questions, Gavin, about what it was like working in his office.
Well, please don't, Mr. Chair.
I could give the praises of the parliamentary internship program with which I worked with Mr. Richards, as well as with Paul Dewar on the opposition benches. I think certainly the size of the bill means that we need to hear from a large number of voices. And the spectrum of voices that we have here today is testimony to that in part. The more substantive point is that there are elements of the bill that I think everyone here supports, and bringing together a wide range of voices to speak to what is in the bill and what could be potentially improved in the bill is a positive step, and that's what I'll say.
Okay, last word was to you. Thanks.
Okay, thank you all, Mr. Julian.
Yes, so we do have the largest Budget Implementation Act in Canadian history. The Speaker was forced yesterday to separate it out into chunks, but I have deeply appreciated your testimony today. I hope it is all will actually have an impact, because what the government has done is established a legislative bulldozer. We have a few more hours of hearings from very qualified witnesses such as yourselves, and then we run into a day where if amendments are not adopted, the whole package is simply thrown back in the House of Commons as is. So my question to you, and particularly to Mr. Youssef, Madame Smallman, Madame Desjardins, is what are the impacts if pay equity is not addressed in any way? Yesterday, the Finance Minister refused to commit to any sort of changes in this bill. As I say, the legislative bulldozer is in place. So what happens if this is adopted without those changes?
Well, let me start. I think, again, the pay equity legislation, as is contained in the bill, address many of the things we've been advocating for decades. Are there some areas for improvement? Absolutely, and we state them very categorically before this committee. If they're not addressed in the way in which we have, I think that it could erode the principle of pay equity for women in the federal jurisdiction, and that would be unfortunate. As one of my colleagues commented, we don't want the courts to be litigating something that's supposed to be a positive onus on employers to ensure this is the fact and reality how women are going to be treated in the federal jurisdiction. So at the end of the day, our amendments, I think, will make it ironclad that women actually are going to be treated in a way that was intended by the legislation, because we've been able to determine these are areas, of course, the court has litigated on at least one provision of it, and of course we see two specific areas in which the bill can be improved.
If I could, if I could just add to that, I just want to refer also to Madame Desjardins' comments about the regulatory process. You know, if we pass this, we still have a lot of work that we need to do in regulation, and we need to have a robust process that, you know, includes some tripartite mechanisms. We need to actually be able to close some of these loopholes in the regulations and explain and clarify some of the gray areas. And so we are anxious to have this passed so that we can move on to that next stage. It would be good to have it passed with the amendments that we're proposing to be able to start us off on the right foot. The other component that I want to recognize also is that the resources that are allocated to the Pay Equity Commissioner and their unit are also fundamental to the success, because if we don't have the right tools at our disposal to implement and enforce the Act, then it will, the process will continue. We already have a timeline built into the legislation that means that we have a lot of steps towards when we will actually see some groups of employees have their wage discrimination addressed. So we're anxious to kind of get on with it.
Ms. Palmer, just to come back though, Mr. Youssef has just said that the constitutionality of the pay equity legislation might be in question. Women might be forced to go back to court. Do you share that point of view?
Yeah, I think that provision, I don't think that we're not saying that the bill itself is unconstitutional. We're saying a specific section of the bill would need to be amended, because the court have just recently ruled in a similar provision in the Quebec legislation, and it's identical, and I think it has problematic application if it's not changed. And of course, as you know, we're very good at taking the cues from the court when we are successful, and we will be back into the courts, and it will be unfortunate for that to happen.
Thank you.
Je veux juste réitérer exactement ce qui vient d'être dit.
I'd just like to say that I agree with what has just been said. Currently, apart from the issue of retroactive payments during the maintenance phase, we feel that this corresponds to the same problems that were raised before the Supreme Court, and which were considered unconstitutional in the case of Quebec legislation. Apart from that, it's a matter of day-to-day enforcement that will show us the gaps in the legislation. It's important to note that if the enforcement is not appropriate and does not allow us to correct for discriminatory pay gaps, it may be considered unconstitutional. In Quebec, there was another case before the Superior Court in 2004, where another large section of Quebec legislation was declared unconstitutional through its enforcement, through its application. That was when it became visible that it was unconstitutional. So all three of you are saying that it is essential that amendments be made to this legislation. Yes. Answer, yes, of course.
Mr. Sabero.
Thank you, Mr. Chair. Welcome, everyone. Great to be here this afternoon with you. This first question to the Canadian Labour Congress, Mr. Youssef. Hussein, we've seen in the province of Ontario the Ford government attack rights of middle-class Canadian workers and middle-class Canadian families in the last few weeks with the repeal of many provisions that would benefit middle-class workers and their families, including sick leave, a minimum wage of going up to $15 an hour, scheduling, and so forth. Our government has decided to stand with middle-class families and middle-class workers. And in this piece of legislation, the BIA, we've introduced changes in the Canada Labour Code, the first such substantive changes since 1960, I believe you referenced. What more needs to be done? I know there's some stuff with regards to contract flipping, contract tendering. If you can provide some feedback on where we are and what else can be done, please, sir.
First, I want to applaud Minister Hajdu for the work that she had done on the Labour Code Part 3 provisions. As you know, it's almost 15 years since Harry Arter first tabled his report when he looked comprehensively as what can be done to improve the Labour Code Part 3 and to see these provisions brought forward because they represent a 21st century reality of workers in this country, and it's fundamental that we get them into law as quickly as they can because it will, of course, be such a contrary to what's happening in Ontario right now, where the government is repealing the things that the most recently was amended to improve the code, and huge swaths of workers will now not have that basic protection in the Ontario Employment Standard provisions in the code. On the contract flipping, I think the provisions that I referenced to in regard to contract flipping is in part of it that the government changes to that section of the code to address, of course, workers that we are concerned about that could not have the protection as this bill has been proposing. And I think we've made that clear to the minister on Tuesday of last week or Wednesday of this week, sorry. She said publicly that she will table some amendments as soon as possible to ensure that that provision is fixed as quickly as possible.
Okay. Thank you, sir. With regards to YWCA, the BIA Act introduces for the first time a Department of Women, Gender, and also pay equity, which is something people have advocated for, been consulted on for a very long time, and something, frankly, as myself being an economist, is something that's good for the economy. And we've seen that the labour force participation rate for women in Canada is now at its highest level ever on record, which is wonderful. And can you explain and comment on how, look, and legislation is never perfect. It can be made better as possible. We know that. At the same time, this piece of legislation is groundbreaking from my humble point of view on pay equity, on a full department. If you can just comment on that, please.
Thank you for the question. The YWCA Canada has been calling, as well as other women-serving organizations, for a very long time for proactive legislation, pay equity legislation, and so we were pleased to see that this was included in Bill C-86. And our colleagues on the panel have spoken about some of the things that need to be addressed to make it even better, but on the whole, in the spirit of the legislation, we are happy with, because this is something that will impact the lives of many of the folks that we serve every day across the country. Our stipulation is that, from our understanding of the legislation or the bill before us, is that there are some exemptions for folks that are in part-time, seasonal, contract work, or non-standard employment. And for many of the people we serve every day across the country, this would not help them. So it's really important that when we consider the legislation before us, that is something that is addressed, because that exemption impacts primarily, disproportionately, women. So that is something to consider as your committee considers this bill. But on the whole, we are quite pleased with the introduction of a department for women and gender equality. We would encourage that this is something that the committee really puts forward in terms of resources in the upcoming budget 2019 to really ensure that this department can do all of the great work that is set out in the bill itself. This is a landmark moment. This is something that we should have in this country, and this is something that our organization, the YWCA Canada, with our over 330,000 people that we serve across the country, are looking forward to seeing what impacts they will make in a tangible way for women, girls, and their families. Thank you.
Thank you, Mr. Sabera. Mr. Kamish.
Thank you, Mr. Chair. So, Mr. Riley King, you mentioned during your presentation about some amendments to the concessionary sovereign loans. Can you just elaborate a little bit more about what kind of changes you would like to see done?
I think the idea is that if you're setting up these new tools to leverage the amount of impact we can have internationally, if you're going to count some of those tools as ODA, then you should be using the same standards by which you define ODA for that and for which you count international assistance.
Okay, one of the concerns that have been expressed by some members is the potential for some of the sections right now and how they would work is that they may cover basically the losses that a private sector participant might experience during an ODA project. And there's a great latitude being given to the Government of Canada here through the Minister to cover up to 100% of the potential losses. Do you think that's all right to leave as is, or do you have any concerns about those sections in the bill?
I think our position with respect to that and with respect to FinDev, the New Development Finance Institute, is that the government needs to put in place very strong measures to ensure that any funding provided to private sector companies is additional, both from a financial perspective. So we don't want to just subsidize companies to do things that they may already be doing. We need to make sure that any finance that's provided is outside of what they might be able to get in the market. So it needs to be financially additional and also developmentally additional. So it's going to have a positive impact on development as well.
Right, so there's a component of moral hazard there, right, where the government might take on a project with a private sector participant in it, and the moral hazard comes from the participant was going to do it either way, but now it gets to write off or potentially could experience zero loss if the project goes sideways. Do you think rules, you talked about having perhaps more tougher rules around how those types of projects are agreed upon by the Government of Canada. Do you think those rules should be legislated rules, or can they be done through the regulatory process, or just like a guidance document? Do you have any preference, statutory over regulatory?
I'm not sure if Gavin has comments, but I think you would need strong public guidance. I don't know that they necessarily need to be regulatory, but I think you'll need, in addition to any legislation that's developed, you'll need very strong guidance, very good disclosure, both pre-project approval and post, so that you can ensure as the public that the guidance that the government has put in place, it is following and is implementing it. You're seeing the impacts that you're expecting. You're able to measure that financial and development additionality both before you can ascertain that this isn't going to be a subsidy, and after that you can see that the investments are actually having a positive development impact.
Gavin, did you have anything you want to add?
Yeah. The only thing I would add is that there are many different ways in which the government can provide international assistance. The Official Development Assistance Accountability Act provides a legislative framework for defining and implementing one element of international assistance, which is official development assistance. And insofar as the new financial mechanisms being introduced are going to be considered as official development assistance, it's important that the strong definition and legislative framework of the ODA Accountability Act are maintained.
Okay, thank you.
Okay, thank you. Just a question to Mr. Youssef. In your exchange with Mr. Sabero, do I, in your submission, you talk about not satisfied with the provisions to end contract flipping in airports and federal workplaces. Did I take it you to mean that this could be dealt with by regulation, or does it need a serious amendment?
Yeah, there is the section that would need to be amended is in the Labor Code Part 1. And certainly our communication with the minister would mean that she would have to table a regulatory change to plug that hole that we have identified.
Okay, can you give us correspondence on that as well, please?
Sure.
Thank you. Mr. Fragaskatis.
Thank you very much, Mr. Chair, and thank you to all witnesses for appearing today. I do want to focus on pay equity. That was the focus of my questions yesterday during our sessions, but I have a number of constituents that are highly interested in this, at least half my constituency for obvious reasons, but beyond that, because it's everyone's issue, quite frankly. If I could start with Ms. Sultana. You represent, or at least you're an organization that has reached out throughout your history to many women and continues to do so. I wonder, with the changes that have been put forward now on pay equity, obviously it's applicable to federally regulated sectors, but can we begin a dialogue, and I think we can now, about how to expand that vision of pay equity beyond and bring in the private sector? And any ideas on how the Government of Canada could work with organizations such as yours and even beyond that to really begin a substantive dialogue about pay equity beyond federally regulated sectors?
Thank you for your question. So first off, I'd like to congratulate and applaud your fellow colleague, Minister Mariam Monsef, for her leadership on advancing gender equality and women's issues in Cabinet and beyond. And in our comments with her and other parliamentarians last week, we talked about the importance of advancing economic equality for women and gender diverse communities, because not only is it good and important for society in creating a more inclusive society, it also has an impact on the economy. A report by McKinsey Global Institute predicts that if there was economic equality for women and gender diverse communities, this would result in a positive gain of $150 billion for the country of Canada. And so this is something that we cannot ignore. If there are barriers to women's economic participation, not only does this have an impact on them and their families, but this has an impact on our collective future. And if we are considering, when I think about the topic that was of conversation for the pre-budget consultations, it was about looking at Canada's economic competitiveness. If we do not invest in women and their economic future, this has an implication on our economic competitiveness on a world stage. In terms of how to partner with organizations such as the YWCA Canada, I would say the fact that we are in 9 provinces and 2 territories, we are ready partners for hosting those conversations, because for many of our constituents in terms of the people we serve, they might not know the full details of what pay equity legislation looks like, but it's critical that the public is fully aware of the way in which this will be implemented and rolled out. So I think it would be incumbent on all of us to ensure that there is broad awareness and education of the broader public when it comes to this issue. I would also say, and I would encourage again, our understanding of the legislation before us is that there are some stipulations that exempt people that work in non-standard employment. So folks that are working in contract, part-time, seasonal, and other non-standard employment from this legislation and the merits that it has, and we would encourage that be something that would be looked at, because disproportionately women make up the workers in those spaces.
I'm going to have to interrupt you there because I see I have about a minute and a half left, and I did want to ask Mr. Yousaf, I told you earlier at the outset of today that my grandmother is a former labor leader, and I want to put that to you. Organized labor, what are the plans going forward that you and colleagues have to continue this fight of pay equity beyond the federally regulated sectors and have it be something that is one within the wider society?
Well, you know, there's three jurisdictions now that will have proactive pay equity legislation: Ontario, Quebec, and now the federal jurisdiction. The federal jurisdiction, a little bit over 1 million workers will be covered by the code, because the federal government is also going to broaden the coverage to ensure that federal contractors program will also have to comply with proactive pay equity legislation. If you're seeking to do business with the federal government, you're going to have to meet that requirement. I think all of this will have an extremely positive impact on women, but more importantly, I mean, this is about not just women's pay equality, it's about their economic equality. Statistics point to time and time again that women, of course, live in poverty much so than men comparatively. A large part of that because we've been discriminating for generations and not paying them adequately. So this is certainly going to raise the standards significantly. But I think now we have to figure out a way, which we will continue to do with our federations and our affiliate at the provincial level. So how do we get other provinces to bring forward proactive pay equity legislation? The other thing I would also say that proactive pay equity legislation, you know, only deal with one aspect of women overall equality, and I think a national child care system where we can have women able to have their children in child care will be a tremendous boost to them really engaging, as we've seen with Quebec history, that if they have the ability, they will of course be giving back to the economy far more than they take out with child care. But child care is an essential part of bringing women's equality in our society to a higher level. I can't say enough about what this will do again for the challenges. The one case we have noted consistently in our presentation, it took 28 years for women to achieve pay equity in one federal workplaces, because that's how the litigation went on and on and on before we were able to kind of resolve it. This will end that history, but more importantly, I think the Commission's role will be a tremendous part of this, because the Commission can encourage the parties as to how to find solutions to their pay equity problem, and I think some of the areas we identify that can be addressed would be a tremendous boost. A lot of people are misqualified in the federal and provincial jurisdiction, and it's critical that those loopholes will be now plugged in Part 3 of the code. But equally so, we want to ensure while employers may have diverse interests, they cannot evade their responsibility how they pay women who work within their jurisdiction.
Mr. MacLeod.
Thank you, Mr. Chair, and thank you to all the presenters. I wanted to ask the Canadian Centre for Policy Alternatives what the price tag would be on the plan that was mentioned and the different categories. What are we expecting?
Sorry,
to
which
see?
plan?
You referred to a plan in your presentation.
We have a recommendation that we submitted to the Finance Committee, I guess this past August or September, on the amount of monies that we're recommending to invest in Status of Women Canada to ensure a vibrant and fulsome mandate of $100 million. Per annum, which obviously money, a good chunk of which supports the department in its work, but also the vitality and impact of their community grants and contributions, which are actually just now having an important, through projects and funding, important impact right now as organizations are working again once this funding. So our proposal was to increase the funding for the department to $100 million per year going forward in light of its new responsibilities, which have now been expanded, obviously, under this Act. Was that was that the plan that you were, the recommendation?
That's what I was looking for. Thank you.
Yes.
My next question is to Canada Without Poverty. I found it very interesting that you talked about adequate standard of living because it's something we talk about. I represent the Northwest Territories, and for us in the North, trying to live to the Canadian standards is a real challenge. And I certainly can relate to the issues that you've brought forward. I represent a riding with many small Aboriginal communities. And we just completed a study on suicide in our smaller communities. And one of the things that we heard was the issue of housing was causing many challenges. And studies that have shown that if we could solve the housing issue, we'd solve probably 50% of our social challenges. Now, that rings true also with poverty, and there's a connection there. And so I wanted to hear a little more on your views on how poverty affects the life of many, many Canadians across the country. And I think it's maybe even more so in some of the small Aboriginal communities.
So thank you for your question. I can't speak for all people who are poor in this country. I can speak to my experience, as an educated professional living 35 years in poverty, 19 years as a single parent. It was an enormous struggle. Having only being able to live in dilapidated housing that had rats in my living space in my kids' beds, making impossible choices between paying half my rent or half my hydro, and I'm a white, able-bodied Canadian-born person who has the ability to articulate these things, and how much more someone who doesn't have the privilege that I have even in my poverty, and how marginalized they are in smaller communities, as you're saying. And I think that housing, and I'm sure Leilani will speak more to this, but if my housing issue of my rats, if I didn't have to live with violent neighbors, if I didn't have to, I didn't have a bedroom of my own, I slept on the couch, and if just my housing was taken care of, I think that would alleviate a lot of stress. I think it would help provide nutritious food on the table for my children, and it's critical that housing is taken care of. It's only one aspect of many issues that affect poverty. It's food, it's employment, it's ability, disability. It's all these complexities that come together depending on where you live in the country. But if one element was attended to, like housing, I think it would make an enormous difference.
I'm here in my capacity as Executive Director of Canada Without Poverty, but I am also the UN Special Rapporteur on the right to housing. Maybe I could speak to you afterward about my concerns, extreme and deep concerns about housing conditions for Indigenous peoples across the country, both on reserve, off reserve, in cities, etc. It is, I think, actually one of the #1 issues that we have to deal with.
You have the best stage in the country right now. You could make the recommendations. Feel free.
We're a little over time, but go ahead, make your point, and then we'll go to Mr. Julian for 3 minutes because we were late starting. So, Ms. Farah, if you want to go ahead.
Thank you. I don't have recommendations because I'm not in a position to make those recommendations right now and here. I haven't. As rapporteur, I have not visited the communities and done an assessment, but I do intend to do something on that issue. So that's why I was suggesting perhaps we could speak afterward. Thank you.
Okay, thank you all. Mr. Julian, 3 minutes.
Thank you, Mr. Chair. I have 2 questions for my 3 minutes. First off, thank you very much, Mr. Youssef, Madame Smallman, Madame Desjardins. We appreciate receiving your amendments. I'm hoping that they will be integrated into the legislation. One element that I wanted to flag is the so-called scissors clause, which is Regulation 181 in the Pay Equity Act, which basically allows the minister to exempt any employer, any class of employers, from the application of any provision of this Act. And I would put to you, is it essential as well to remove that scissors clause that basically allows any government, current or future, to say pay equity doesn't apply? The whole banking industry could be exempt, for example. And my second question is to Canadian Council for International Cooperation. There have been concerns raised about the provisions that allow federal government funding for the private sector in the event of a loss, guarantees that are in whole or in part, allowing foreign aid, in a sense, in development assistance to underwrite the private sector and private sector profits. Are you concerned? I imagine you're addressing that a bit in your comments. Are you concerned if the bill gets through without amendment those particular provisions.
Je vais répondre à votre question sur la clause.
I'll answer your question on the scissor clause. That's the first time I've heard that expression, but that's exactly what makes Chapter 9 of Quebec's pay equity, what made it unconstitutional in 2004. This section of the legislation allowed certain employers to be exempt, and powers were given to the Pay Equity Commission. There were criteria to be used that had to be used by the Commission. Despite the existence of these criteria, some employers were exempted, and ultimately the constitutionality of these decisions was called into question. The Superior Court of Quebec said that it was unconstitutional, and the Quebec government never appealed. It's clear that if it's left to the minister to determine this, we will end up before the courts if the section remains in the legislation. I do not think that this will be able to be enforced by the minister if it remains in the legislation.
I would say that a blank check to a private sector company without ensuring development and financial additionality should not and cannot be counted as official development assistance. Of course, if the government still wants to do it, that's its prerogative, but it shouldn't be counting it as ODA.
Okay, Mr. Youssef, you want
to? Yeah, just very briefly. I don't want to elaborate that, except to say that you can't exempt an employer from their human rights responsibility. It will be a fundamental breach of human rights commitment. And I'm sure that, that I hope this is not what is intended to excuse an employer to apply their responsibility in a way that is equitable for the people who are affected by the decision they make.
Okay, with that, thank you all. Thank you to all our witnesses for your presentations, and I do know it was on fairly short notice, but I think everyone's presentation was very thorough, so on behalf of the committee, we thank you for that. We'll suspend for a couple of minutes and ask the second panel to come up. reconvene for panel 2, looking at Bill C-86, Second Act to amend to implement certain provisions of the budget tabled in Parliament on February 27th of this year. Just before we, first of all, thank you all for coming on short notice and with a big bill. We do have votes tonight, and I'm told bells are now at 6:15, so we should be able to go to 6:30 likely. I think it's a 30-minute bell. So with that, then, we'll start with the Canadians for Fair Access to Medical Marijuana. Mr. O'Hara, President and CEO. I believe you're over there in the corner. Go ahead.
Thank you, Chair, and to the Standing Committee for the invitation to appear today. My name is James O'Hara, and I'm the President and CEO of Canadians for Fair Access to Medical Marijuana, commonly known as CFAM, and I'm a medical cannabis patient myself. CFAM is a national nonprofit organization which has successfully represented medical cannabis patients since 2014. We speak on behalf of the approximately 350,000 medical cannabis patients in Canada today. Our organization has emerged as the thoughtful, legitimate, grassroots voice for medical cannabis in the nonprofit advocacy space today. Let me begin, Mr. Chairman, by saying 25%. 25%. That's the average amount of tax that has been applied on medical cannabis. 25%, and in many cases that's low. So fully a quarter of the cost of a patient's medicine is consumed by tax today. It's essential to understand that affordable and reasonable access to medical cannabis is absolutely critical to a patient's health, well-being, and ultimately their lives. Yet that's not what we have today. In fact, we have the complete opposite in the form of a significantly tax-burdened medicine. Let me take some time to recap some of this government's rationale for taxing cannabis. The Right Honourable Justin Trudeau has stated many times that non-medical users will flock to the medical system and abuse it. Given cannabis legalization was implemented last month, this is no longer a valid reason. He has also stated many times that legalization has been put in place in order to defeat the black market. This is also no longer a valid reason. This is because these burdensome taxes now do the complete opposite, and that is to encourage a black market, not defeat it. In fact, there's more reason than ever before for a black market to exist. And let me give you a measure of that, Mr. Chairman. I can honestly sit here today and tell you categorically that I've never, ever in my life heard so many patients tell me they will no longer support the industry, and instead they'll go to the black market, the very black market that Mr. Trudeau is trying to eliminate. It's also been stated by many sitting members of this government in written form to their patient constituents that medical cannabis patients need to pay the costs for legalization and enforcement. Mr. Chairman, let me remind you that we've already paid. We've been paying for almost 20 years. We've paid that bill, and then some, even before legalization even existed a very long time ago. And let me add a lesser-known fact here. Medical cannabis patients do more than pay. They save this country and companies in costs through less medication, fewer doctor visits, hospital visits, and less sick days. Members of this government have also stated that there's an excise tax exemption for medical cannabis patients. The bar for this so-called exemption is anything less or equal to 0.03% THC. Mr. Chairman, that is not medical cannabis. That's the THC level of hemp. And in the end, this is a political defensive measure simply put in place to confuse people and is effectively no exemption for patients at all. The latest version of medical taxes justification appears to be the DIN argument. Mr. Chairman, there are already tax-exempt products today which have no DIN. The reality here is this is just another stall tactic on the part of this government in order to continue to collect taxes from health and economically challenged Canadians as long as possible. So whether it's the story of non-medical users cheating the system, black market elimination, or medical users having to pay a bill, or false exemptions, or DINs, these all lead to a single obvious truth, and that is this government desires the tax revenue at any cost. And let me tell you something about that cost, Mr. Chairman. These taxes come at a far greater cost than any one of us, including myself, is capable of ever imagining. It's paid for in the pain, the suffering, and death of literally hundreds of thousands of Canadians each and every day. I'd like the members of this committee and the MPs who have supported these taxes that each and every time you state another reason as to why taxes on medical cannabis should exist, please remember who you're saying that to. You're saying this to your ill mother, father, grandmother, grandfather, uncle, brother, sister, whoever, and your constituents, because medical cannabis patients are all around you. They're amongst us. And realize that you can only justify this practice if you're either seriously misinformed or have no compassion whatsoever for the daily struggles of health and economically challenged Canadians. In closing, Mr. Chairman, it's on these very compassionate grounds that I call on this government to end all taxes on medical cannabis immediately. I want to thank you, Mr. Chairman, and this committee for the time, and I'll be happy to answer questions you may have. Thank you.
Thank you very much. Turning then to the First Nations Lands Management Resource Centre, Mr. Louie, Chair of the Advisory Board, and Mr. Bear, Chair. Who's on? Mr. Bear? Mr. Louie, go ahead.
Thank you, Mr. Chairman. Good evening, honourable members of this committee. My name is Robert Louie, and I am Chairman of the Lands Advisory Board. My Okanagan Syilx name is Simu. Simu is our ancestral name, which means connected to the land. I am here with colleagues to speak to this committee in support of the amendments to the First Nations Land Management Act, which I will refer to as FN-LMA, in Bill C-86. We hope that all members of this committee will support these amendments as set out in Division 11 of the bill, and that the legislation will be passed as soon as possible by Parliament. This is a legislative step Canada takes to make the Act conform to the most recent improvements to the Framework Agreement on First Nation land management we originally proposed to Canada in 1994 and signed in 1996. Though we support the amendments to the FN-LMA in Bill C-86, we wish to raise with committee members the need for future reforms to replace the FN-LMA with a more appropriate and efficient approach, one that better respects our government-to-government agreement. I will begin with some background on this most important and historic accord, the Framework Agreement on First Nation Land Management. I am a former chief of the Westbank First Nation, a self-governing community, and have worked for many years now to advance self-government over our lands. I have chaired the Lands Advisory Board for close to 30 years and since its inception. With me tonight is my colleague, Chief Austin Bear of the Muscoda First Nation in Saskatchewan, who is chair of the First Nations Land Management Resource Centre. This is the technical and finance arm of our organization. Both of us worked together as part of a group of 14 First Nations in the 1980s and early 1990s, seeking a way to escape the draconian laws and policies of the Indian Act. We were driven by a desire to obtain recognition for our inherent right to self-government of our reserved lands and resources. After many years of negotiations, research, consultation, and extensive discussion, we signed the Framework Agreement on First Nation Land Management with Canada in 1996. The old and grossly outdated Indian Act land system held our communities back and did not respect our decision-making and our traditions. The old system did not meet the needs of community members and harmed our ability to participate in the mainstream economy at the speed of business. In 1996, we signed the Framework Agreement on First Nation Land Management with Canada. This Framework Agreement was ratified by Canada when the FN-LMA was enacted in 1999. In accordance with the Framework Agreement, individual First Nations have the recognized authority to make decisions regarding their own lands and can promote healthier and more vibrant communities with direct economic benefits for First Nations and indeed all Canadians. Through the Framework Agreement, we are awakening and improving areas of the Canadian economy that were depressed by the outdated Indian Act. This is a win-win solution. Let me re-emphasize, a win-win solution. Self-government over lands is not only practical and effective, but is a step towards meeting Canada's commitments to self-government under the United Nations Declaration on the Rights of Indigenous People, which I will refer to as UNDRIP. I begin with this focus on the critically important issue of self-government over lands because it is vital for committee members to understand that the Framework Agreement is the heart of the matter. The legislation to amend the FNLMA in Bill C-86 and indeed the entire FNLMA exists only because of the Framework Agreement. Canada chose to ratify the Framework Agreement in Parliament through the FNLMA, but all the detail of the agreement on self-government are found in the Framework Agreement. The purpose of the most recent FNLMA amendments is to reflect the amendments to the Framework Agreement that we developed in full partnership with Canada. We are not FNLMA First Nations exercising self-government under terms imposed or delegated by federal law. We are Framework Agreement First Nations. The Framework Agreement is First Nation-led, and it drives the FNLMA, not the other way around. Under the Framework Agreement, First Nations resume the independent exercise of self-government over their lands. First Nations do not need any agreements with Canada or any federal legislation in order to exercise the inherent right to self-government. However, part of the value of signing the Framework Agreement with Canada is the national recognition of this exercise of self-government combined with Canada's recognition of the need to dismantle the failed Indian Act in a measured and careful manner. We see the Framework Agreement as the centrally important document in a new relationship with Canada and all Canadians regarding reserved land governance. It is a Framework Agreement that First Nations signed to enter the process, and it is the Framework Agreement that First Nations ratify in order to exercise self-government pursuant to their own laws. The Framework Agreement is not imposed on all First Nations by Canada. Participation in the Framework Agreement is entirely voluntary. The Framework Agreement only applies to those First Nations that choose to ratify the agreement. The Framework Agreement is flexible so as to respect the particular traditions and priorities of individual First Nations. In each and every case, it is up to the members of individual First Nations to decide whether or not to leave the Indian Act land provisions and exercise their own self-government over lands. Each First Nation decides whether to ratify the Framework Agreement approach through their own land codes. There is no one-size-fits-all approach, no single land code or set of laws imposed by Canada or by the Framework Agreement. This is good, and is what First Nations want. We believe this to be one of the hallmarks of its success. The Framework Agreement is remarkably progressive and thriving. There are now over 200 First Nations who have either ratified a land code or in the process of developing a land code or who have submitted official notice of their intent to participate. This means that approximately 30% of all First Nations communities in Canada are involved today in this very important Framework Agreement and what we're doing in land management. The Framework Agreement was developed by just 14 First Nations, but now, 22 years later, 81 First Nations have resumed their land governance authority, and there are 57 more First Nations actively considering this option right now. Budget 2018 envisions an additional First Nations over the next 5 years. We, of course, would like to see this number increased. Although the Framework Agreement has been successful from the outset, we have also successfully worked with Canada on a number of improvements over the years. I think it would be beneficial to highlight for committee members of these most recent amendments. First, the Framework Agreement was developed before UNDRIP. Many First Nations operating under the authority of the Framework Agreement see Canada's recognition of UNDRIP as an important step towards reconciliation and respect for self-government that should be reflected in the Framework Agreement and in federal legislation. First Nation voters called upon to consider land codes want clarity. The new UNDRIP clause in the Framework Agreement will be important to voters considering whether to opt out of the Indian Act land system because it signals Canada's commitment to an approach consistent with UNDRIP. With respect, I think that the UNDRIP language in Bill C-86 could be improved. Right now, it says that Canada is committed to implementing UNDRIP. That is fine, but more explicit language might include words to the effect that the interpretation of the Framework Agreement and this Act should be guided by the principles established in UNDRIP. The second change we wish to emphasize to this committee is the amendment to the voting process for land codes. In almost all of the votes we have seen across the country, there has been overwhelming support for land codes. In 2 First Nation community votes, there was unanimous support amongst voters. On average, land codes are supported by 84% of voters. However, in some cases, where there has been an overwhelming majority vote in favor of a land code, it may be surprising to committee members that those land codes votes have still failed. This is because the Framework Agreement has not only required a majority vote in favor, but also that a minimum threshold of 25% of all eligible voters must vote in favor of the land code.
Can you fairly quickly sum up? We're considerably over time. We'd like people to try and hold it to 5. Go ahead.
Well, thank you very much, Mr. Chairman. I'll try and go through this a little bit quicker and paraphrase a little bit more. I want to point out to this honourable committee that just this past month, when Brunswick House First Nation Ontario held a vote with 153 yes votes and only 16 no votes, the land code still failed. Only 9 more votes were needed. This Bill C-86 can change that. I can assure you that the success of the First Nations with Framework has been overwhelming. This is, in fact, the 6th amendment to the Framework Agreement, and well, there's so much I would like to say, Mr. Chairman, and I appreciate the aspects of this. I wanted to state something about the misstatement of the purpose of the Framework Agreement and some of the summary policies and things of that nature.
We do, Mr. Louie. We have a copy of all members have a copy of the submission, so they will have what you have sent us in writing. I just we're double over time, and maybe you could further that in answers to a question. I'm just starting to worry a little about time.
Thank you, thank you very much, Mr. Chairman.
And when you used the word frame, I think you're just so the members are clear. You really mean the Framework Agreement on First Nations Land Management?
Correct.
Okay, good. Thank you. Then, and I'm sorry to cut you off. Intellectual Property Institute of Canada, Mr. Lyons.
Thank you, Mr. Chair and committee members. As mentioned, my name is Grant Lyons. I'm the immediate past president of the Intellectual Property Institute of Canada. Thanks very much for inviting IPIC to present to you our initial thoughts on Bill C-86 and to answer any questions. As you may know, IPIC is the Canadian Professional Association of Patent Agents, Trademark Agents, and Lawyers Practicing in Intellectual Property. IPIC represents the views of Canadian IP professionals in many submissions to government and other bodies.
Grant, could I slow you down a notch? The folks in the booth here are having a hard time to keep up.
Nah. I guess I was just trying to make up time I didn't lose. IPIC represents the views of our IP professionals to many government submissions and other bodies. Our activities include a wide breadth of activities in education, continuing professional development, raising IP awareness in the business community. And for the past several years, we've even created a voluntary code of conduct for our members in order to belong as a member of our institute. Now, in the past few days since C-86 was tabled, we've had about 160 of our members looking at the provisions with the proposed changes to the Patent Act, the Trademark Act, and the Copyright Act. In that brief few days, we've been considering the wording, but will no doubt want to put in a written submission given the scope of the detailed proposed changes. There are a few examples that immediately hit our members, and I'd just like to touch on those. Some changes, one in particular is a change for what's called known as file wrapper estoppel in the patent litigation field. And this was introduced by new Section 53.1 in the Patent Act, which is essentially the ability to introduce prosecution histories. This is the back and forth between the applicants for patents and the Patent Office into judicial proceedings. Now, this would change many years of our Canadian judicial precedent. This provision was introduced with little notice or debate and not mentioned as part of the national IP strategy. More specifically, though, our members felt that there is a lack of an appropriate transition period for this provision, especially with respect to active patent litigation, and the fact that existing patents that were prosecuted or obtained when this legal doctrine was not part of Canada's patent laws, but based on this new provision, the doctrine would apply immediately if and when these patents are enforced. Now, in hearing from our committees that looked at C-86 in the past few days, we can say most amendments are supported by IPIC in principle, but there are many areas when used in practice would create, in our view, unintended consequences. And I'll just summarize those. Some examples would include prior user rights in patents, a continuing lack of a requirement to show use of a trademark to obtain trademark registrations, and the statutory damages remedy for collective societies in the copyright, which appears to remove the availability of statutory damages in regard to sound recordings. We'll provide a detailed submission to the committee as soon as possible, identifying these potential issues. With that said, our priority in the remaining brief time we have is really to focus on some aspects of the bill that create the College of Patent and Trademark Agents. Now, as many of you know, we are happy to see this enabling legislation in C-86. IPIC has been advocating for the desire to have such a governing body for almost 23 years. And looking at the legislation, what I'd like to capsulate really is two items that struck us that we'd like to raise as concerning issues. The first issue really relates to two provisions, Section 14C and D of the Enabling College legislation. So Section 14D, in effect, prevents IPIC members who have sat on one of our committees, one of our 37 committees, in the preceding 12 months from being eligible to sit on the college's board of directors or other important committees of the future college. It would also exclude those who have been volunteers of other organizations representing our profession in Canada and internationally. Now, IPIC, we've got a great membership as far as volunteers. We have more than 400 volunteers sitting on our committees, which is about 1/4 of our membership. These are the profession's most engaged members and often the most senior, most knowledgeable people of the profession. Taking into account that these would be excluded, our view says that after that exclusion, you're really left with an extremely small pool of candidates who have the necessary experience and knowledge to sit on the college board. As an example, we have many committees that deal with professional development. We have members that deal with the federal court in regard to changes in federal court litigation. We have public awareness committees. One is actively advising on Indigenous IP issues. All of these members, based on this provision, if they had sat on these committees in the preceding 12 months, would be excluded from the leadership, the board positions of the college. We believe this rule is unnecessary, or this provision is unnecessary. It's also inconsistent with other professions. For example, the Law Society of Ontario does not have such a restriction on its board members, its benchers, and in fact, they encourage the members to be actively involved in voluntary associations. So in our view, the emphasis should be to repeal Section 14D and C. 14C would actually make a member of IPIC ineligible for the board based on membership alone. Our view is the legislation should not prevent the college from having the best chance possible to succeed. The college should have the most qualified pool of candidates available for its leadership. And the second and final issue I'll highlight in our remaining time pertains to Section 33 sub 1 of the college legislation that requires the inclusion of a code of conduct in the regulations. The code of conduct should be a living, breathing document, and there's a rapid pace of involvement or evolving change in both business and the IP profession. and we believe it is very problematic for the code to be part of a regulation. The code is often written into the bylaws, or it's a reference by regulations, but it should live outside the regulations. We recognize that the code may be deemed to be a regulation under the Statutory Instruments Act, but allowing it to exist as a bylaw or some form outside the regulations gives the college the ability, the flexibility to be nimble, to amend the code efficiently, and react as a one-stop organization as a guardian of the public interest. To give an example again, looking at the Law Society of Ontario, the code of conduct for them is called the Rules of Professional Conduct, which are not embodied in the regulations under the Law Society Act. The benchers or the Law Society Board oversees and approves the Rule of Professional Conduct, but the rules are not the actual regulations under the Act. The authority to make the rules and bylaws comes from the Law Society Act by way of legislative delegation. And our view that there
Grant, you're starting to pick up speed again, I'm told, but and you are going to have to finish up. We're considerably over time here as well. Go ahead.
Absolutely. Thank you, Mr. Chair. I'm just going to wrap up and say, in many cases, the code is created through bylaws, and there are already several provisions in the legislation that provide for very strong oversight by the minister, such as the majority of public seats on the college's board appointed by the minister, the ability to remove a director for any reason, and even to require the board to do anything the minister feels is necessary. In our view, the best place for the code is not part of the regulations, and that would give the college the best ability to react, be the safeguard of public interest, and have the flexibility to revise the code and treat the code as a living document for all of the members and the public. Thank you.
Thank you, Mr. Lyons. Then turning to Envision Insight Group Incorporated, Ms. McKay, Secretary-Treasurer, Nisga's Nation, and Mr. Mahaffrey, Senior Policy Advisor, Carcross Tegnish First Nation. Welcome.
Amayuksa Tanux Nisup Blam Next White Whoops Height Massful Witquit Luam Scotty Nibble Gassam. The English translation of my Nisga'a name means Pearly Fin. And I've said good evening to you all. It's good to see you all. As Mr. Chairman has stated, my name is Corinne McKay. I am the elected Secretary-Treasurer of the Nisga'a Nation. We thank you for the opportunity to present to the Standing Committee on Finance. I would like to start by noting that the Nisga'a Nation was the first Indigenous nation in British Columbia to enter into a modern-day treaty, and I have a copy with me. The Nisga'a Treaty was also the first modern treaty to be constitutionally entrenched as a self-government. I note some of the contents of Bill C-86, amendments to the Income Tax Act, the Excise Tax Act, introduction of Pay Equity Act, changes to the First Nations Land Management Act, and many other changes. It's always positive to see budget implementation bills that acknowledge and seek to address the needs of Indigenous peoples. This builds on the Budget 2018 announcement of specific funding for self-governing Indigenous governments. This was the first time that the needs of Canada's modern treaty partners were explicitly acknowledged in a federal budget document. Future budget processes, including budget implementation, should continue to build on these positive developments in two ways. First, the needs of self-governing Indigenous governments should always be taken into account and be specifically addressed in the budget. For example, there should continue to be specific allocations to self-governing Indigenous governments of any infrastructure or housing or gap-closing funds. And I note that there was a discussion on housing just prior to our presentation. And it's a very real need in our communities. And the status of housing in our communities are still much to be desired to improve the housing conditions of our people. The second is future fiscal policies related to self-governing Indigenous governments should be developed collaboratively. The Government of Canada acknowledged the failings of its pre-existing fiscal policies and invited self-governing Indigenous governments to participate in the collaborative fiscal policy development process. It is important to note that this process is separate and apart from the government's engagement with the AFN, or Assembly of First Nations, and it is engagement directly with self-governing Indigenous governments. In this collaborative process, Indigenous government representatives and federal government representatives work closely to develop a shared understanding of the interests of both Canada and the Indigenous governments. They build a new fiscal policy from the ground up. This has never been attempted before. It is important to recognize that the collaborative process for developing policy has resulted in a package of fiscal policy documents that are more respectful of the circumstances and the needs of the Indigenous governments, as well as the commitments Canada has made in modern treaties than any previous federal fiscal policy. This work is to be praised and to be emulated. All future fiscal policies should be developed collaboratively. We thank you for the time to hear the support that we have for the collaborative process. We find it's respectful and it builds on the work that has been done, and we see that this is the start of a new dialogue that will improve the lives of our people and, as Canadians, improve the lives of Canadians. Thank you.
Thank you very much, Ms. McKay. I'll probably date myself here, but I remember well the night more than a night, 37 hours of voting it was on the legislation to advance the Nisga'a Nation. I'm probably the only one that's still here from that time. Public Service Alliance of Canada. Ms. Picard, National Executive Vice President, and Ms. Berry, Legal Officer. Floor is yours. Welcome.
Alors bonsoir, je vous remercie de me donner l'occasion.
Good evening. Thank you for giving me the opportunity to present before you today on behalf of the Public Service Alliance of Canada. I will speak about the new Pay Equity Act, which is in Part 4 of Division 14 of Bill C-86. On the whole, PSAC is pleased with the proposed Pay Equity Act. For decades, our union has been at the forefront of fighting for women's right to equal pay for work of equal value. While we have had successes, the time it took to get results through a complaint-based process often meant that the women who did the work and should have received the pay died before they touched a penny of it. PSAC believes this act is a good step towards redressing existing pay inequities, while at the same time creating a culture where equal pay for work of equal value can flourish and become the norm. We are pleased to see that a Pay Equity Commissioner and unit is being established. However, we caution that it must have sufficient resources to be able to fulfill the important role of ensuring the successful implementation of the Act. We have two very important concerns about the proposed Act as well. Section 2 states that the purpose of this Act is to achieve pay equity through proactive means by redressing the systemic gender-based discrimination in the compensation practices and systems of employers. However, this laudable language is undermined, unfortunately, by the following phrase, while taking into account the diverse needs of employers. PSAC is concerned that the inclusion of this statement in the purpose of the Act may give employers significant legal weight to be able to challenge decisions of the Commissioner. They can argue that the needs of the employer are equal to the advancement of pay equity as they are both articulated in the purpose of the Act. Legal scholars and the Supreme Court of Canada have weighed in, and there has been debate about the objective of this purpose clause. We do not believe it was the government's intention to undermine the objectives of the new proactive law. That is why PSAC recommends that this committee amend Section 2 by deleting the following, while taking into account the diverse needs of employers from the purpose clause. We recognize that responsibility to achieve pay equity resides with the employer. Nonetheless, there are multiple provisions in the Act allowing an employer to apply to the Commissioner to request flexibility, extensions, and exemptions that will support the employer's diverse needs. Now, I will raise our second concern, which is on Section 20 of the Act, dealing with decision-making on employer-employee pay equity committees. The section states that members who represent employees have as a group one vote. A decision of a group counts as a vote only if it is unanimous. This gives the employers a major advantage. In practice, this would give non-unionized employees a veto over the preferences of unionized employees, and vice versa, while also giving bargaining agents vetoes over each other's proposals. It is conceivable that this system would most significantly disadvantage representatives of female-predominant classes over those who may not have the same interest in having a robust pay equity plan. Again, PSAC does not believe that this was the intention of the government in an act that is trying to redress systemic gender wage discrimination. PSAC would then ask the committee to amend Section 20 by removing a decision of a group counts as a vote only if it is unanimous. And we would also need to remove the following sentence. If the members who represent employees cannot as a group reach a unanimous decision on a matter, that group forfeits its right to vote, and the vote of the group of members who represents the employer prevails. We believe these two amendments are essential to the effective implementation of the new law, and we urge the committee to amend the bill accordingly. Many members of PSAC have a great deal of experience when it comes to pay equity, and we look forward to placing our expertise at the service of government, of the federal government, during the development of regulations and any related activities. My colleague and myself will be happy to answer your questions. Thank you.
That's Part 4, Division 14, Section 20, right? Yep, I'm pretty sure.
Absolument.
Thank
oui,
you.
exactement.
Turning to Mr. Guest as an individual. Welcome, Michael.
Great, thanks. Good evening. My name is Michael Geist. I'm a law professor at the University of Ottawa, where I hold the Canada Research Chair in Internet and E-commerce Law, and I'm a member of the Centre for Law, Technology and Society. I appear today in a personal capacity representing only my own views. I'm pleased to have the opportunity to discuss the intellectual property provisions found in Bill C-86. As you know, Budget 2018 prioritized the national IP strategy, and while aspects of that strategy involved investment in issues such as IP education, there were several legal and policy commitments that required legislative reform. Many aspects of Bill C-86's IP provisions, I would argue, are both long overdue and welcome. Since abuse of intellectual property rights may inhibit companies from innovating or discourage Canadians from taking advantage of the digital market, crafting rules that address misuse can be as important as providing effective IP protection. There are several examples of how the bill addresses the issue of IP misuse. For example, misuse of Canada's copyright notice and notice system, which was formalized in 2012 to allow rights holders to forward allegations of copyright infringement to Internet users through their Internet service provider, has been an ongoing source of concern. The bill amends the Copyright Act to ensure that settlement demands are excluded from the notice and notice process, thereby restoring the original intent of the system. Patent changes to address patent trolling provide, I would argue, another important reform. The bill seeks to combat patent trolls by creating new minimum requirements for patent demand letters, which should discourage the sending of deceptive letters. The rules also include a right for a recipient of one of those letters to pursue damages or an injunction at the federal court. It also includes, the bill, provisions that expand prior use rights, address standard essential patents, and create safeguards for research, with the rule that deals with acts committed for the purpose of experimentation, not being an infringement of the patent. In doing so, I think the bill restores a better balance that supports innovation within the patent system. The bill C-86 also includes notable reforms to the Copyright Board, including, I think, an important reference to considering the public interest in the decision-making process. That's something that the board would say that it would do. Making explicit in the legislation, I think, is the right thing to do. It also rightly does not include an expansion of statutory damages amongst the extensive reforms. Arguments in favor of expansion were unconvincing and would have usurped the role of the Industry Committee, which is currently engaged in a detailed review of copyright. I think that issue will still be hotly debated as part of the copyright review, but that committee is the appropriate place for discussion of statutory damages, not within a package of largely administrative and governance reforms to the board. While this represents the positive in the bill, I think there's still some room for improvement, and I wanted to quickly touch on 3 recommendations. First, the implementation of some of the reforms, including the patent reforms that I've just described, are likely to be delayed for years since they're structured to require regulations to define issues such as the requirements to be contained in a patent demand letter. Officials on a call just last week indicated they already know what they'd like to see included. The long delays undermine the likely success of the government's IP policy and innovation strategy. I see little reason not to include those requirements within this bill, as I don't see any reason for the issue to be left to the regulation-making process. Secondly, the notice and notice copyright fix is good, but we can still do better. There should be penalties for sending abusive notices. We know that many Canadians, thousands of Canadians, have unknowingly paid hundreds or even thousands of dollars in these cases, and we need penalties for those that abuse the law in this way. And there should be common standards established to make it easier for Internet providers to identify compliant notices. Third, Budget 2018 includes several references to artificial intelligence, AI, one of Canada's most important innovative sectors. Yet despite the prioritization of both AI and the IP strategy, it leaves a major AI copyright barrier untouched. Several of the world's leading AI companies, including Canada's Element AI, Microsoft, and members of the Business Software Alliance, have pointed to the need for an exception for text and data mining or informational analysis. Without such an exception, Canada trails badly behind competitor jurisdictions such as the United States, Europe, and Japan that have already addressed this issue by allowing for data mining without the risk of copyright liability. Canada should not wait years to address this commercialization barrier. Given the budget's inclusion of both AI as a priority and intellectual property, Bill C-86 is an obvious place to fix the problem. I look forward to your questions.
Thank you to all of you for your presentations. We'll go to 5-minute rounds. Mr. MacLeod.
Mr. Chair, and thank you to all for coming here to present. I represent a riding that has a large Indigenous population. The majority of people in my riding are Indigenous. And it makes me feel really good to see that we have 2 delegations here from Indigenous communities, Indigenous nations, so thank you for coming. And I think it's the first time I've seen anybody at a committee from the Land Claims Coalition, the self-governing nations, I believe. I might be wrong, but welcome to everybody. And I've said it many times, but I want to say it again, that as we move forward, reconciliation and self-government requires a new fiscal relationship, and I think we need to hear more about it. So my question goes to Envision. I want to ask you to explain to us, how does the First Nations Finance Management Act work for self-governing nations? And maybe I could add a second question. I wanted to, maybe you could talk about how it intersects with the collaborative fiscal process.
The issue with the First Nation Finance Act is that, like many of the institutions that Canada has set up for Indigenous people, it leaves out self-governing nations. It deals with Indian bands on Indian reserves, and it doesn't provide for access to the bonds for self-governing nations. The amendments that have been developed deal only with Indian bands. So all of the changes that are there exclude in self-governing nations, and this has been a challenge that that Indigenous governments with self-government agreements and comprehensive land claims have faced since the very first modern treaty. Is that while Canada is entering into these agreements, they're not changing their policies and their processes, and looking at the institutions that they're developing and ensuring that they're done in a way that addresses the commitments and the changes that have been brought about by these new agreements. So self-governing nations are falling through the cracks when Canada is developing solutions. So the First Nation Finance Authority and the processes that are set up there are important. It's an important tool for Indigenous governments, but it doesn't, the way it's been established and the way these amendments have been developed, it again eliminates the access for self-governing nations, which means that those nations either have to borrow funds at a much higher rate, or they have to save the money before they can spend it. And when the challenge there is that when you save that money, it has been used as a challenge in negotiations with Canada, because you saved that money and you have a big surplus in the bank, but it's because you don't have access to financing, so that's the only way you can accumulate the capital that you need to develop infrastructure in your communities. And the only way that programs and services that are designed to eliminate the gaps between Indigenous Canadians and non-Indigenous Canadians are going to be successful is if we have the kind of infrastructure that's necessary to ensure that there's clean water, safe housing, and a community that's equal to what other Canadians take for granted. And so we need the Government of Canada to work with us. This is a topic that we're dealing with in the collaborative fiscal process, which consists of all self-governing nations in Canada except for one, working collectively in an effort to develop a comprehensive fiscal arrangement with Canada. And that's what we need. One of the challenges is that everything's to date has been done sort of in silos and in isolation. So it limits the benefits of each of those things, and we need it to be done in a comprehensive way so that we can access the resources that we need, but we need that to be done in conjunction with a fiscal relationship that ensures that Indigenous governments get the appropriate share of the wealth that's generated from their territory, and are able to then use that to provide services to their communities. You can't be expected to borrow our way out of poverty, but we do need access to financing in order to deal with large expenditures that will then be amortized over many years. So we need all of these pieces to come together, and we need the Government of Canada to ensure that its policies and when you're developing laws and policies, that comprehensive land claims and modern treaty nations are not left behind.
Thank you. We'll have to end it there, but that was a very thorough answer. Thank you, Mr. Commish.
Thank you, Mr. Chair. Mr. Linz, I just want to focus on and ask you a bunch of questions about the college. You said your institute, and I looked up your institute online, has been calling for the creation of a college for a long time now. Maybe you can explain to me, has there been, is it a serious issue? A lot of people misrepresenting themselves as trademark agents. Typically, that's why professional colleges are created. That's my first question. But before I let you answer, my second was, you mentioned you had amendments you wanted to propose to the BIA. When were you thinking of getting those to the committee?
As soon as you need them, which is probably yesterday, I'm guessing.
Tomorrow, basically.
Yeah.
Because there's a programming motion that was passed by the opposite side over our objections that basically forces us to be done by November 20th, and we have to put in our amendments by that. That's for everybody here, just so you know, that if you have amendments you'd like to see being proposed by either side, you'd have to have them in to us as quickly as absolutely possible, because we have to submit them in by, I think, 5 p.m. tomorrow, and the clerk can correct me if I'm...
15.
By noon?
15.
November 15th.
November 15th? So it's quite quick, and there would only be 5 more days of consideration. And November 20th, it's clause by clause. So we have to get them in right away. But if I could just hear you on the college, is there just a maybe I've totally missed this, a rampant issue of trademark agents or people pretending to be trademark agents?
No, and if we could talk about patent or trademark agents, no, you can imagine we're a pretty conservative profession. So no, we don't have a history of bad behavior at all. Our impetus, our motivation for advocating for a college of this sort for 20-some years is to have a self-regulated profession that stands alone. So you've got professional advisors for intellectual property for businesses. So we want to be part of that business cycle of developing intellectual property with all of our businesses. And part of that is to have a self-standing governing college akin to other professions, be it engineers, medical profession, legal profession. And these advisors are experts in acquiring and advising companies on how to acquire intellectual property rights in Canada and dealing with those rights with corresponding people internationally.
Sorry to interrupt, but they're doing that already. So do they need a college? Because a college also typically confers onto a person who registers a protected title. There's some disciplinary procedures that can be taken up against members, but if you're saying that it hasn't been like a rampant issue of people misrepresenting themselves or people failing to meet certain professional standards, because you also mentioned you had concerns about the way the legislation was going to structure the standard and the code of ethics, about where it was going to be located, statute versus regulation versus bylaw. Can you explain some of those concerns?
Sure. I mean, as an association, voluntary association, we're engaged in a lot of these activities already and have historically been for our members. Continuing professional education, that's a core part of what we do. The aspect of a college really embodies all of the professional education requirements and really elevates the view of patent and trademark agents to the public, to the businesses, to say this is a self-standing governing profession that is expert at advising you on intellectual property rights. So I think it really elevates and has a self-standing college to govern the practices, the educational requirements, so you can say to businesses, we are experts at doing this intellectual property rights advising with you, acquiring those rights. I think it really is a self-standing body akin to other jurisdictions in other countries to say these are our professional advisors. We're going to help you build your business, especially intellectual property rights.
And for the standard and the code, the concerns you expressed about where it would be located, can you just repeat that concern?
Absolutely. So I mean, you've got an act, a legislation under an act, so the college is proposing the act. You're going to have regulations under the legislation. Our view is absolutely there should be a code of conduct or a code of ethics. We have one ourselves. It's voluntary. We believe the most appropriate place is in the bylaws or outside the regulations within the control of the board so they can see how it should be amended over time. Whereas if it's in the regulations, you've got the added hurdles of getting through the gazetting process and getting it into the regulations if you feel it needs to be amended. It's more cumbersome. So we're not saying don't have a code of ethics. Absolutely have a code of ethics or a code of conduct. We just think it's best placed outside regulations in, for example, bylaws, where you can deal with it as a living document, show the members, show the public, and if there's changes to it, then you bring it to the board, the governing body of the board, and propose amendments to the members.
Very short.
Very short. I'll just mention, typically in professional associations, there's Tier 1, Tier 2 associations. So the model you're talking about would make you on par with professionals such as engineers, accountants, physicians, surgeons. Tier 2 professionals are the ones that are typically smaller in scope, so Alberta Shorthand Reporters, for Institute, the Institute of Planners. There's just a lot of these smaller associations. All of them typically will have their code of ethics and their standards in a regulation embedded into it. That's pretty common in Alberta. I used to be a registrar for a smaller profession. That's not atypical. And as much as I don't like defending what the government does and how they do it, like this doesn't seem all that unreasonable to put it into a regulatory framework, especially for trademark agents. So I'll just leave it at that.
Okay, Mr. Julian.
Thank you, Mr. Chair. Thanks to our witnesses, particularly Mr. Louis and Ms. McKay, Mr. Mahaffey, who've come from the other side of the country to be here today. We appreciate your being present and being witnesses. I'd like to start briefly with you, Mr. O'Hara. We know from the last BIA that it was rushed through. There was a mistake made, and that was the imposition of an excise tax on medical marijuana. And I remember sitting around this table and asking this of officials, and the officials weren't even aware of the mistake, but the government refused to amend the legislation, rammed it through. What has been the impacts of the government rush to ram through legislation, even with huge flaws? And are you suggesting that we amend this BIA so that we can remove that excise tax from medical cannabis?
Yes, to start with your last question first, yes, we would like to see that removed. The impact has been very, very significant because you're now talking compounding taxing. You're talking tax on tax, and that is already put medicine, which is already very difficult for most patients to fund because they're economically challenged. Also, it's been put out of reach even more. So absolutely, we should rescind that.
OK, merci beaucoup. Je vais passer maintenant à Madame Picard.
Now I'd like to ask a question to Ms. Picard. We've seen some of these errors that have not been corrected. We've had several witnesses up till now who have indicated that there are major problems with the Pay Equity Act. In your opinion, it is important or essential, as we've just heard, that we carry out these amendments to change the Pay Equity Act so that it makes more sense and that it works in practice? Answer: absolutely, it's essential. The bill, or the bill in its current form, opens the door to employers to ultimately defy the wishes of the government. The government wants to eliminate pay inequity. However, ultimately, our main priority is to see this bill adopted. It's a historic bill. It's very important. So while we would like those amendments to be made, I can also say that at least we should get started with this bill and then we can continue to work on things together. But we have only 2 amendments to propose. And in our opinion, with these amendments, we have a bill that will be welcomed by the unions and especially by women. But these amendments are essential. Would you not agree? You're telling us, well, don't you feel that we can't adopt the bill with these gaps in it without it leading to problems later, right? And that's what we heard earlier this week as well from witnesses. Women feel like they're going to have to go before the courts if the bill is adopted in its current form. I'll try to be as clear as possible. As far as we're concerned, if I were given a choice between not getting the bill adopted in its current state and getting it adopted in its current state, I would say we should go ahead and get it adopted, even though we don't like every aspect of it. To be perfectly honest, I would be very concerned to see the bill set aside because there are still amendments that should be made. Things have been, well, this type of legislation is long overdue, and we should act. We don't want to still be in this situation in 100 years. Of course, right now the bill isn't perfect. However, notwithstanding that, we would prefer to get the bill adopted in its current form, and later we can work to get those amendments made. And I'd just like to seize the opportunity to ask our legal expert.
Something, but that's the way that's our approach.
Mais vous partagez, si je comprends bien, l'inquiétude.
But if I understand correctly, you share that concern that women will have to initiate legal proceedings if the bill is adopted in its current form. And as for the scissor clause, which means that the minister can exempt exempt any employer or category of employers from all of the provisions of this bill. If I understand correctly, well, other witnesses have said the same, that a minister or a government in the near future could decide that we're simply going to cut out all of these sectors, or exempt them from pay equity. For example, banks. So I would think that you want to remove that section.
Can I respond? Yeah. Yeah, so I agree with what Madame Picard said, that we don't want this to not be passed. PSAC has waited a long time for this legislation. As far as from a legal perspective, we don't know, I mean, whether there'll be legal cases necessary in these provisions. I mean, we're thinking that that will happen, but there's also provisions in there and in every other act that we don't know how we're going to have to react to it as the union for many federal public service workers. So, you know, I think moving forward with this act is very important to PSAC and to our members. It has been a long time coming, so we are very supportive of it. We do encourage you to look at the amendments. We've made two simple, well, reasonably simple, recommendations for the amendments, and we'll be following up with written submissions on a little bit more detail on those amendments that we're requesting.
Thank you all. Mr. Fergus.
Thank you very much, Mr. Chair. I'd like to thank all of our witnesses for being here today. I will continue in the same vein as Mr. Julien. Ms. Picard, Ms. Berry, firstly, thank you very much for being here and for what you've said. There's an expression which is that we don't, well, I would amend to say we don't want the good to be the enemy of the excellent. There is a chance to make progress here. But this is a step in the right direction of pay equity. I'm interested in the criticisms that you have voiced about this bill, but I would just like to let Ms. Berry to add what she wanted to add earlier. Mr. Julien, next to last question. I would be interested in hearing what you were going to say, because it looked from your body language like you had something to add. Could you please go ahead? Would this be a good chance to say what you were going to say?
And I don't speak French, so I'm listening to the translation. I'm not exactly sure what my body language said.
So I think you were going to make a comment as to how much the or whether or not you thought that parts of the bill would be challenged legally. I thought you were going to make a point on that. So.
Yeah, the point really is that we don't know at this point what parts of the bill or any bill that we will have to challenge. We've come across, PSAC, and you probably know this, has come across a lot of legislation that we've challenged and had to challenge. And sometimes we don't recognize what aspects of the law will become problems until we're going down that road. So, you know, so we don't know at this point that for sure these will cause litigation or long litigation. We don't know. Again, this is better than the 30 years that we spent on the Canada Post pay equity case that the Supreme Court finally ruled on in 20 minutes. You know, and as Ms. Picard said earlier, many of our members have worked hard and not received pay equity, and it goes to their estates when they're dead. So we don't want to see that. This is a good first step. We think it's an important first step, and I think it will lay the groundwork for equal pay for work of equal value to be the norm in society. And I think this is a, you know, so we see some areas of difficulty, but we certainly see some positive areas as well.
Merci beaucoup pour ça. Madame Picard, avez-vous...
Thank you very much. Ms. Picard, do you have something to add? No, I have nothing to add. Thank you very much. I'd like to thank you for PSAC's statements. Now, Mr. Geist, thank you very much as well. I noted your second recommendation.
Of copyright infringement. Vous avez dit que c'est encore une fois un bon départ.
Regarding notice, you said that it's a good step in the right direction and that amendments could be made. In your opinion, do these measures meet the problem appropriately, and how could things be improved?
As you may know, the notice approach was one that was adopted back in 2012 as a better mechanism to try to educate Canadians on the boundaries of copyright and to provide rights holders with a mechanism to raise that awareness while still safeguarding the privacy of users. The problem that emerged almost immediately is that because there were no regulations or limitations on what could be included in a notice, and internet providers were required to forward whatever they got under potential penalties for failing to do so, we saw certain companies sending out settlement demands to unsuspecting users and sending out literally hundreds of thousands of these with unsuspecting people simply clicking and paying hundreds of dollars when there was no requirement to do so. What this bill does is a very important step by saying an ISP won't be required to forward on a notice if it includes any of those kinds of settlement demands. That's great, but I don't think it goes quite far enough, because what it does is, in a sense, put all the obligation on an internet provider to fully examine whether or not there is a notification or not, a settlement demand or not. Hopefully they won't forward those notifications, but given the volumes, there are still risks that some of these may go through and costs that may accrue. I think that we could improve this first by making clear that there is a penalty for violating the rules of using this system to send along notifications. And so at the moment, there is no penalty for doing so. The worst that someone who does that faces is the possibility that their notification won't be sent along. But if they send out hundreds of thousands of these, some may get through, and there's no penalty for doing so. It would be, I think, fairly easy to say there's the prospect of some sort of violation or penalty if they've actually violated the rules in that way. The other thing that we could really benefit from is, because of the volume, creating a standard form of what is to be included within that standard form would allow for greater automation, reducing costs, making it simpler for end users to receive it. And we don't have a clear-cut form either. And so it's really, in a sense, fine-tuning, but allowing, I think, the intent of what the government's trying to achieve, which takes us back to that original intent, that could really, that I think could improve what's a good first step to try to get back to what was intended in the first place.
Okay, thank you all. The bells are ringing. Are we okay with committee members to go another 15 minutes? That'll give us, we've got 28 minutes left, so.
Really close.
What?
10 minutes?
10 minutes.
We're only 5 minutes from the chamber.
Some of us are faster than others, I know that.
Okay, Mr. Commish, the floor is yours.
Thank you, Mr. Chair. Just back to Mr. Linz. You mentioned Section 14 CD, the provisions that exclude some of the members of your institute right now from being able to run for the board. You had mentioned that these would be your most senior members in the profession. So essentially, the more junior members would be the ones who would then run for board position. But currently, right now, like I'm guessing you have an operational kind of group of committees. So you have some doing maybe like conferences or something, CPD conferences.
Yeah, we have a wide breadth of committees, from organizing our annual conference, their educational aspect. We have committees that deal with litigation, like I said, a litigation committee. So a wide breadth of areas of IP are embodied by members joining committees, and we encourage members to join committees to get involved, learn more about IP, learn more about the educational aspects of the profession, and involved in giving webinars and seminars to our members.
Do they get any CPD points, so continuous professional development points towards, certification, current certification, or?
Yeah. So if they do belong to bodies that require it, absolutely. Our courses are qualified. I know for sure, as a member of Law Society of Ontario, depends on which courses are, but yes, they can be qualified.
So these provisions basically would exclude the most active members who are involved in your profession from participating in their own profession's college.
That's right. You're right.
Okay. Can I just, sorry,
No, you've got it.
Now we got the bells going, so I need to ask the next question. In here, there's protection provided for the title of the profession, but not an acronym for the profession. So just from my personal experience, you have the accounting profession is a good example. In their colleges, in their regulations, in the law, their statutes, typically they will protect the word accountant and variations of the word accountant, and as well they'll protect CPA, CA, CMA, all the old varieties. That acronym, if this passes the way it is right now, because there is no acronym in here, to the best of my knowledge, you will have people who will want to pretend to be trademark agents, will just simply use an acronym. I don't know if that's ever been noticed by members of the Institute. And it goes back to the question, like, is there like a large amount of your current members who engage in maybe the provision of services that they're not supposed to or they're not qualified to? Or are there people out there pretending to be trademark agents?
Yeah, it's a bit of a, there could be a gray area. I mean, it's pretty clear if you're doing business before the Patent and Trademark Office, you have to be, in those rules, set up as a patent agent or trademark agent to represent a person before those offices. And those are the titles you see that are carried forward in the legislation for the college. There are others out there, you'll see advertisements that will use different phrasings, but they don't encroach on, or at least they shouldn't encroach on patent agent, trademark agent. So I think the short answer there, if I can make it as short as possible, is we don't see a lot of nibbling around the titles that are true and accurate to what our professionals are doing, the patent agent and trademark agent. And part of this is education, which we embrace, is to get the businesses to recognize who is a qualified patent agent and a trademark agent, and the necessity of education that goes into that, as opposed to somebody who carries on themselves as a business advisor in intellectual property.
Do you mean businesses like businesses in Canada, or do you mean international businesses? Like who's having the difficulty figuring it out?
I think for the most part, it's probably mostly SMEs that we're dealing with in Canada. Internationally, we deal with intellectual property rights and counsel from other jurisdictions every single day. There's generally a regarded acknowledgement of the profession in Germany, in the UK and Australia. So we don't see it as much internationally, perhaps, as we do in Canada. If you're trying to get SMEs involved in protecting their intellectual property, you want to make sure that they get the right professionals to be their advisor and obtain their rights before the Canadian Intellectual Property Office.
How much time do I have left? Just 1 minute. So maybe just to go back to, just as a suggestion, because I think that maybe an amendment I might propose is, and maybe other international jurisdictions have an acronym also that goes along with the protected title, but that will be a source. Trust me, there will be individuals out there who will see it as an opportunity to misrepresent themselves by using the acronym to get around some of the rules that have been created here. That's why the accounting profession, engineers, lawyers, and others protect the word and the shorthand title. It's just a cover-all, just to ensure that people don't misrepresent themselves, especially when you have a college that's created. It gives it another opportunity to misrepresent in advertising, especially now with the advent of online advertising. That's the popular way to misrepresent one's professional qualifications. So I'll just leave it at that.
Okay, thank you. Before I come over to Mr. Sabara for the last round, Mr. Louie, I know you come a long way. There's been no questions to you and Mr. Baer. Do you want to take a couple of minutes to sum up your point you didn't get to make?
I would appreciate. Thank you very much, Mr. Chair, and I certainly understand the patience here of the committee and the time delays. I just want to sum up by this: we are in support of the amendments here. When we're talking about UNDRIP, these are very important provisions, and I think all of the federal legislation needs to reflect this. We're certainly very supportive of the majority vote. Because in this particular case, while we've had two First Nations that have unanimously passed their land codes, both of them in British Columbia, Lake Cowichan and Yakwekwiyus, we've had 33 First Nation votes across Canada that didn't achieve the threshold, despite votes. When they did their community votes, they ranged from 51% to 90% approval, yet didn't pass on the first go-round. So, but I want to emphasize only 7 votes in the past 20 years were outright no votes. So having this amendment here with the majority vote is absolutely necessary, and I applaud the committee members and Parliament for this. Yukon lands, having the land set aside, this is very important. We want Yukon involved. Yukon and is there, so having the inclusion for Yukon First Nations is great. Having the ratification officer replace the verifier will save a lot of monies, and this is good. The administrative use of electronic votes is very much desirable. The fact that that not only revenue monies can be transferred to a First Nation when it passes a land code, the fact that capital monies that are held in the Ottawa Trust account through Department of Indian Affairs. That's very, very important. Enforcement provisions, there are some good aspects in that regard. And of course, the additions to reserve. My own community, for example, spent 17 years on one particular reserve to get it added to the reserve while we had full provincial support. So anything that can expedite that through ministerial order, as proposed here, is certainly going to help. So things of that nature, we applaud, and we thank you very much, Mr. Chair, and the honourable members for having us here.
Thank you. Mr. Sabara, last round.
Thank you, Mr. Chair. Just a quick comment for Ms. McKay. I was born and raised in the riding of Skino, Bulkley Valley, and Prince Rupert, and know the area, the beautiful area that you live in and everything, and you're from. But I do want to speak to Michael Geist and to Grant Linz. I'm not an IP expert. I'm not an intellectual property or copyrights expert. It's very, and I've tried to get up to speed very quickly. My understanding is that the information contained in the BIA, the legislation in the BIA, there's a lot of good stuff in there, and I'm happy with that. But there's also some, I've heard some things that we may need to look at, or may just a second glance at. A minute each, Grant, and then over to Michael, if you can comment where we can improve on these aspects.
You mean overall in all of the legislation?
Well, the legislation that pertains to IP and copyright.
IP and copyright, yeah. So I think the areas on the patent side, we've touched on the file history estoppel, which I think is new section 53.2. The major issue with respect to that was really the timing that came out of our members. Because of the fact that it's enforced right away, so that would impact current litigation. And current litigation, you're dealing with experts who have been advised of the state of the law, and the file history estoppel that is brought in with this new legislation was not part of our regime. So I think that's the biggest aspect that where we could improve is to address the transitional aspect of that section, and at a minimum say that should not apply to any action or proceeding that is ongoing right now. I think there's a little bit of transition time needed if that's the provision that's going to come into force.
Okay. And over to Michael.
Yeah, sure, thanks. Well, I touched on with Mr. Fergus a couple of the possibilities with respect to the notice and notice provisions, how they could be improved. Two others, just to reiterate. One, I think some of the patent changes are very, very good, and they've been long discussed, especially around the issue of trying to deal with patent trolls. I think the problem is that we know what we want, and yet by putting it off into the regulation-making process, we're delaying the effectiveness by several years at a time when innovation is a significant part of the government's overall strategy. And so, given that the department says they know what they'd like to see included, I don't see any reason why we couldn't include as a start precisely, let's say on patent demand letters, what the requirements would be so that this could take effect at the same time that the full bill takes effect, as opposed to putting this off by several years. The other, as I mentioned, has to do with linking the IP strategy issues and copyright with the emphasis that we've seen on artificial intelligence, on AI. We've now had just about every major player in the AI space argue that there is a significant barrier within the copyright system that they do not face in the United States, in Europe, in Japan. And so given the investment that we've put into this, it's a one-line change within the Copyright Act, which would make it clear that there is an exception for what's known as informational analysis or text and data mining. What it effectively allows us to do is allows those that are engaged in artificial intelligence research and later commercialization to ensure that the data that they're using can be used without fear of engaging in copyright infringement.
Okay, thank you. Mr. Chair, can we have Mr. Geist forward that one line to us? Can we request that?
Sure, yeah. If you can, Michael, can you forward that to the clerk?
And also for the same reference to Mr. Linz, if we can, through you, Chair, we can have Mr. Linz forward the same information that's pertinent to your concerns, please.
Yeah, just forward the information related to your concerns, Grant, to the clerk.
Absolutely.
And as quickly as possible. I think somebody made the point that we need this information fairly quickly.
Thank you, Mr.
Okay?
I'm done. Thank you.
Okay. Then thank you for committee members, 8:45 tomorrow morning in the room across the hall. Thank you to all the witnesses for your presentation and putting the effort into your submission and your work. Thank you. Meeting adjourned.